what you do. You don't check yourself. You say, hey guys, how does it sound?
I'm checking by my because I'm checking by my phone based on the delay through YouTube. It sounds okay.
Okay.
I'm just gonna bring it a little bit closer because it doesn't. Here's the thing: because your microphone's better than mine. I'm using the basic Snowball Ice. I don't have the volume knobs that you have, so I have to. I don't get to balance out my sound exactly the same. Yeah, see, Rob says I sound quiet. See, that's a problem. Let me
Oh.
looking at the audio. Let me turn up the
Usually it's
mic.
my mic that's quiet. That's crazy.
No, you're like you sound balanced. You sound clean. You sound everything sounds well. Everything on my end. On the other hand, sometimes it's faint. And who's Kenny Edits?
It fucking
I'm Asian today.
what it just started that like a month ago, and now you're just Asian Joe.
That's fine. I don't care. Asian Joe attorney at law. That's perfectly fine. All right, turned up my mic a bit. Give me some feedback from the audience. Do I sound like I'm in the same room as Tristan? That's important because I don't want to go back and forward all throughout the stream trying to fix this.
Right? Because Robert said, we can't tell. You're talking over Joseph. No.
Yeah, well, I did turn my mic volume down because I had audio issues last time. Rob says sounds better.
Okay.
I'm gonna give it a little bit more volume.
Happy birthday, Random!
How old are you?
Happy birthday. It's Bianca's birthday too.
Today?
Yep, both of them. Happy birthday, guys. We're going to do a celebration tomorrow because she's off work and I'm stealing her.
All right, well, I'm going to have to go to her Ko-Fi and leave a gift.
Bianca is adorable, but her mom is so fucking cute, and she messaged me yesterday. Like, her mom messages me. I love her.
Yeah.
And she sent me a picture from their birthday, and I'm like, oh my God, they're so cute. Because she has a twin sister, too.
Really?
Yeah.
I knew she had a sister. I didn't know they were twins. I don't know anything about any of you people. I don't know who the hell you are. You used to write articles, crazy. So did Rob. I found that out one day.
Yeah, I used to write. But
I've been here 2 or 3 years and I don't know anything about you people. It's crazy.
It was like 5 years ago. It was I gave up on that because I wanted to focus more time on this. Plus it was like don't objectify women. I'm allowed to say Bianca is adorable. God. Freaking Gary already this morning. No, I'm just kidding, Gary. But also it ended up being like kind of this I don't know the right word, like chuddy, like anti-SJW website, you know, where it was like everything is dying, everything is dead, entertainment sucks, the comic book industry, and I was just kind of over it.
And now here you are 5 to 6 years later. What do you believe? Do you believe entertainment? Do you believe entertainment is great?
No.
Do you think Blue Beetle is peak entertainment?
I think if you're talking about how do you say his name? Yolo?
He says
the main actor.
He says Sholo, but it's supposed to be Zola Mariduena. Yeah.
If you're talking about peak entertainment and you're including him in the conversation, I would not say Blue Beetle. I would say Cobra Kai.
Oh, okay.
There is some good out there. Yes, absolutely. Is there some mid and some bad? For sure, but that's kind of always been around.
I think it's more so bad than mid. I had a great time with Harley Quinn. I'm so glad it's obviously it's going to be renewed.
I think it's good.
Yeah, and hopefully they take some steps back because this is about that time where a series might start to feel a little bit dim compared to earlier seasons because the crew gets less. I don't know about less creative, but it feels like they struggle, and artists try not to feel like they're doing the same thing over and over. I don't want them to try too hard and overthink it. I want them to have fun with it because that's what they did for 3 solid seasons. 4 was good, but I felt like it was it felt a little experimental. It felt like there were some areas where
with her being the hero, and yeah, I totally get it. I do think that is peak animation for me. Stuff like that, stuff like Arcane existing. There is good entertainment out there. I don't want to be one of those people that just hates everything. And that's a reason why I had to step back and get away from that kind of mindset, because it's irritating, right? Because if you hate everything, you're looking at everything new through that lens, right?
But if you hate everything, you suck as an individual. But if
Well, that's
everything
fair.
else
That's
sucks,
fair.
yeah. Well, yeah, but if everything else sucks, that's really not a you problem. And the truth be told, most of what we get sucks. Wednesday Addams is a great character. The show sucks. Take Wednesday Addams out of that project, and nobody will miss what's left. That's how you know. She carried the whole thing.
Wait. Hold on. I think a lot of people would disagree. I only saw one episode, so I can't say anything. But I do know it was very popular for a while.
This chick is nuts, guys.
I saw one episode, and it kind of looked to me like it was going to be like Wednesday Addams meets Harry Potter. So I wasn't really into it. But I know a lot of people
are there.
Yeah,
actually, you're not even the first one to say it. That was actually a heavy criticism of the show. It felt like a lot of people thought they just put Wednesday Addams in a Harry Potter setting.
House of Dragon. See, I haven't seen that one. I'm not a.
I'm watching Invincible right now. I'm upset
oh my God.
They had to divide the season. It's driving me crazy because the show has a way of making you want more over and over.
Like, but I do find it odd. Spoilers, guys. If you're not caught up on Invincible, wait, are you caught up?
I didn't watch the most recent episode.
Okay, never mind.
Let's leave spoilers out of it. Let's get to it. What are we reviewing today? What are we starting with?
We are starting with this hilarious post, okay? And it's my hilarious post, but I want to get your raw reaction. Because I'm catching up on comics, right? I've been very behind on that. Mortal Kombat is serious business, guys. So I've been super bad about delaying covering comics, and I know I should, so I've been catching up. And I read Nightwing last night from last week. Just read this and tell me what you see here.
I have to zoom in on that. My brother's. Let's see. Well, a number of conclusions. Oh boy, that's a wealth of conclusions. I don't know, James. What would you think if you turned the corner and you heard that?
Oh my God. This is Tom Taylor for one, who was, and I know you're not super familiar with like names when it comes to comic book, but he wrote, John Kent, gay Superman, right?
Yeah.
So I am speechless. I read this last night and I reread it and I reread it and I reread it. And I sent it to Bianca and I'm like, is this what I think it is?
Well, this woman on the left, is she a lovable human being? Let's start there.
Okay, so her name is B. She used to date Nightwing when he was shot, and he was Rick Grayson, that terrible story arc. When he left, when he got his memories back, he still loved her, but it wasn't the same because he wasn't the same person, so he left her. Now she's the Pirate Queen. And she is the adopted daughter of the old captain. So the real brother hates her. And he is thinking that he is the heir to the pirate franchise. Oh my God, this is a real conversation we're having right now. But they're all trying to take over her spot. And this was one of the people that were part of her crew, but was a mole. And maybe he meant this to be bitch.
But this is so open to interpretation, and that's the fun part. I feel like this is the start of a meme. You know what you really should do? If you count the letters, let me see. 1, 2, 3, 4, 5, 6. It's 8. It's actually, here's the thing. He used 6. He actually used 8 characters. Did he use 8 characters until does it cut to something else?
Yeah, he gets punched.
Oh, okay. So with 6 characters, wow, that is fun. But if he got punched, that means he got interrupted. So
I don't know. It doesn't look good. I honestly can't believe this got past editorial.
I'm glad it got past editorial.
I know. I'm laughing at it. I'm actually shocked that nobody. See, that's the thing. I'm shocked that nobody's talking about it because it's very like blatant in your face. But at the same time, I'm kind of not because are people reading Nightwing right now?
Now they are.
Yeah.
They want to
Now
know
they're
what's
like,
next.
what the fuck? Come
Fuck
on,
yeah,
now I
they
need to
are.
know what's going on.
This is the kind of quality that keeps you coming back for more. What we really need to see is the punch.
Oh my god, I thought that was hilarious.
You understand? You could cut this into a meme right now, right? Cut it in half based on what we're seeing here. Cut it in half. Put her on top, him on bottom. The punch third. I bet you this will surface as a meme.
Oh, that
Just
would be
based on people
hilarious.
making edits to the speech bubbles.
Oh my god. Oh my, you don't even have to. It's so bad you don't even, I mean, but yeah, that would be funny. I just can't believe DC. Yeah, for sure.
Well, that's the thing you don't know. That's the fun part. That's the fun part of doing something like this. People input their biases. They jump to their own individual conclusions. And then we have fun moments like this where people are just so mad, they're shocked, they're all I guess we're all having fun right now. This is good, but I could see a lot of people taking this further.
Yeah, taking this the wrong way.
About them. Yeah, if you're just a reader, making it about them, making it about you.
That could be feminist. Technically, feminist isn't a dirty word, but I see your point there.
I think we need a Thunderdome because feminist is one of the ugliest words I can think of.
Oh my god, no. Feminist has been hijacked
all
by a bunch of
idiots. All this talk about what not to say around black people. How about feminists? I think that's a word that the FCC needs to start striking down.
Oh my god. I've seen a bunch of feminists were mad, and there's this one feminist that I actually like that reviews movies and stuff like that. I've shared her videos before. She's really good. But she was super mad at this comedian. Did you hear about this? Matt Rife, I think his name is.
The headline rings a bell, but a lot of times I don't read the stories. I wait
because he was talking about the size of women's clits, and then it made a domestic violence joke. And then on his Instagram post said all to people who, yes, all in the same thing. And then
the same breath.
No. But same Netflix special. And then on his for people that were offended, he put on his Instagram story type thing. You could click here, and it took you like to helmets for mentally disabled. Like, it was fucking hilarious.
He's working for that money. Goddamn.
It was so funny, but so many people were mad. Maybe it would say, no, come on. I know hominis.
Yeah, it's not. That's too many letters. It's too many characters at play. Well, hopefully this guy's not smiling bright at the world when the brick goes in through his window. His teeth are expensive.
Too freaking funny. Okay, I do have a funny video before we start, and then we will start. I seen this morning, and it's only 2 minutes long, and I know I'm obsessed with Mortal Kombat, you guys, but it's funny, so shut up.
What do you say we settle this man to man?
That looked provocative.
Wait, you mean
yes? Right here.
The whole thing is Mortal Kombat, but it's horny.
Critique our form. Come on, let's Madam Bo.
We are not here to among ourselves. We are here to for Earthrealm.
You shall him, Johnny Cage.
Ready for your close-up? I know I'm to Melina, but will I also Tanya?
If you tomorrow, the symptoms of your disease could manifest. Are you ready,
I love the
Earthrealmer?
use of it.
I am, Your Majesty.
Then next, you my daughter.
There should have been a protest
When
right
I'm
there.
finished here, I will you.
Douse the fires! Who set them?
All of you.
They are animated by fragments of souls. Once alive, they tirelessly.
Father would turn in his grave if he saw this. He was a doddering old.
Please, Princess, just listen. We shouldn't. Come any closer, and you'll feel the points of my.
Forget the others. Liu Kang.
Enough with the empty flattery. If you want our trust, give us ass, not words.
Give us ass. And so he obliged.
Liu Kang.
The same one who you in Shang Tsung's courtyard.
Everyone who today did so fiercely. Unfortunate it all ended
Oh my
so
God.
fast.
It's
What
so
happens
good.
when it's
It's so dumb.
The
But it's
Wait, what's
so
that
funny.
with Spider-Man?
Oh my God. What the fuck? Okay, this must be what his channel does. But it's hilarious. I love these, like, what are they called? I've seen
Did
a
you
channel that does this, like
You see
random
the webs,
sensors.
right? You see
No!
where the webs coming from?
God's ass. Oh my God.
You have to turn the
Unnecessary
corner to see where
censor,
the web's
that's
coming
what it
from.
is.
Yeah. No,
Oh my
I think this
God.
guy took it to a distinct direction. We need to build a trophy for this man.
Oh my
This
God.
man, woman, or child responsible, because this is excellent.
Like, playing the story mode, I never fucking thought of that. I should have thought. Oh, see, I could have got a viral video. Hilarious. Goodness gracious. Okay, so now moving on to our main subject at hand. Oh God.
All right.
Eric July.
Yeah. So yeah, Eric July, king of the titty tassels himself. Huh?
And
So
just to let everybody know, he is the biggest Eric July stan. He loves him.
The hell I am. No, I have I haven't said anything nice about him since I first saw the guy. The first time I saw the guy, he was doing an interview with Gothics. And I don't have anything against him. I want everyone to understand, especially because Eric could be listening. And in all likelihood, someone's going to run this by him. No, I actually don't have any personal dislike of the guy. I have some criticisms of the way he's actually handling some of his decisions. But at the same time, you don't have to buy this stuff. I think you're a fool if you're buying into most of what he says anyway.
For sure.
No, by all means, I got jokes. I've said lots of things about him in some very strong words, and I still got plenty more to come in the future stream. You have no idea. You know, I've cracked my jokes like ISOM shouldn't offend. That ISOM means that idiots shouldn't offend ministries. Okay, let me leave that out there. But that doesn't mean I believe in what is being done against him right now, and that's what I'm here to explain to people as we go over. Yeah, that's the position I'm really defending, and it's going to explain to people as we go over these documents or anything else you're going to throw my way, that this really is not as clear cut as people think.
No, and I don't think it's as clear cut, to be fair. And like, just to make my position clear, I obviously am not an Eric July fan. I don't agree with most of his positions, but I didn't really have a huge issue with him until he kind of made it personal. It was very weird for somebody to come up and make a video about a tweet so it was a video about a tweet from John Della Rose of all people, right? About a video that was at that time nearly 2 months old, and it was a short without context, because I do that from time to time to drive people to the main video. Where I don't even know what I said, but he basically told me to shut my mouth or he's going to expose me. Okay.
All right.
Expose away, buddy. Still waiting on that. But honestly,
the good stuff.
Honestly, okay. For his comic book stuff, he's doing well when it comes to like building a core audience. I do think his numbers have clearly shown that a lot have dropped off, right? It went from 4 million to 2 million to 1 million now. Like, he's losing substantial amount of money each time he makes a new comic book. But you're never going to replicate the success of a number one in that form or fashion anyway. But I think a lot of it comes down to his behavior, the way he treats people, the way he, like sending that night letter to Ethan Van Sciver. Basically, a lot of what he does is no one's fault but his own. He's got nobody to blame. Same with this situation. And that's what I said in the video. This is not the International School of Ministries' fault. This is Eric July's fault for not doing basic research.
Well, we're going to see here as this unfolds. Maybe he did do his research. The trademark law is something newer to me. I started doing this research really based on, just based on this unfolding on your channel. My experience with my teacher, and before this goes on, just in case anyone new here, is you're coming here for the first time. Let me explain. I'm not an expert of any kind. I had the privilege of being in close contact with a former constitutional instructor. So I have a lot of lessons that came from him directly. Civil law wasn't really my strongest point. It had mainly to do with case law and U.S. Supreme Court decisions, which usually revolve around criminal appeals. But something like this, like I said, I started researching more so based on because you were covering the situation so much, and you asked me about it. So I had to look into what courts actually do in situations like this. And it's really not clear cut. People who think that the 4 little letters ISOM are just make this an open and shut case. No, it does not. There are a lot of doctrines at play. There are a lot of questions courts are going to ask. Some of the things that we're going to go over in the letter from the ministry's lawyers are actually in and of themselves useless. No, Eric had an extension to respond to this letter until December 4th.
Right.
Let me start right there. So people may think that Eric has not responded because he's not ready. And that isn't true. I learned this because I sued a former employer for retaliation.
Wait, you had to sue someone?
Yeah, I
oh my goodness.
I ended up not even really getting it far. I didn't fully understand retaliation law, but now that I know better, I would be more prepared for something else. But the federal office I went to, called the EEOC, anybody could go there if they have a valid claim. They will investigate if you make a claim, and they will tell you that your employer has 45 days to respond, but don't expect anything sooner than day 44.
Ah, okay.
Right. And reason being, everything you say, this is all going under oath. Hey, if you guys really want to understand how courts think, you really have to understand the oath. When you give that oath that you were going to tell the truth, that's where the presumption of innocence really starts. No, I don't sue anybody. No, that was the one time I sued, and yeah, just no. I wish I had such prowess and resources, sir, but unfortunately, I'm a loner on this. But anyway, you have to understand the oath. You are saying that you will tell the truth. You've all seen it. You swear to tell the truth, the whole truth, nothing but the truth. That's when the presumption of innocence really begins inside the court. Cops don't assume innocence. They're part of the prosecution. Their job is to look for evidence of guilt. The courts have to assume innocence, and it starts with the oath. So the statements you give are presumed true until contradicted, and that's where the value of impeaching testimony comes from. Well, you know better as cross-exam, where the other side gets to ask any valid questions and actually dissect statements for any inconsistencies for the jury to weigh. So nothing is valid until it's under oath. And the people who claim to be related to this, who say they're related to this case, they have to be valid. Everything has to be authenticated. Then we're going to move on. In fact, let's move on to the first page that the first thing that comes to mind in this. What are we starting with?
Probably the basic paperwork that they sent, but that doesn't answer what you said in the beginning. Why do you think he did not respond?
No, he has not responded yet because everything he's saying is going under oath. Any inconsistencies can be considered evidence against him. So it is
okay, but he had time to respond, so this wasn't served.
Because you take your time to make sure that you know exactly what you want to say under oath.
But that time has expired.
No, he got an extension to December 4th.
I don't think you understand what I'm saying. Okay, yes, I understand that. But this whole thing did not have to be served whatsoever. He could have worked with the ministry and avoided this being served. Yeah.
And that is one of those things that makes me cast doubt on his own arguments, because if you believe that there were terms to be settled on, that's somewhat of an admission of liability. Seems
Okay.
to me. I just wouldn't have said that at all. I would have said no settlement because I'm not doing nothing wrong.
I think, and I get that, and that's kind of where I'm at with it. I think they wanted some sort of power, so to speak, over it. They wanted some sort of, okay, well, your character can do this, but it can't do this. Or maybe it was a money issue. They wanted a licensing fee. I'm sure that's probably why he didn't respond. But I do think that this could have been handled a lot better because he went off. This is actually a really good idea.
Yeah, I just wrote in the chat. I like that, but I actually do want to consider that.
I like that name even. But the way my issue with it, before we go into, you said he's got till December 4th now.
Yeah.
When it comes to him,
okay.
Is the way he handled it was going to only make it worse for him in the long run because he came out and he made a video. First off, bad idea, right? Bad idea.
Both of
Don't
them
say
made
anything.
videos trying to bias the world in their favor. The ministry had their own. You covered theirs. Eric had his own. They're both trying to bias people in their favor. So that doesn't really say anything. But you have to remember the biases stated out of court are not the same as statements under oath. Now, again, Eric has time to respond to this. Everything you say under oath matters. You can implicitly admit guilt if you are not careful with your words. So yes, it is in everybody's interest to take your time on this. If you're going to go under oath and say anything, you're going to plead self-defense, or you're going to say this lawsuit should be dismissed, whatever the hell is the case. You do want to take your time. That's you, that's anyone in this chat, that's Eric, doesn't matter how much you like him or not. Everybody should take their time and make sure that's especially important.
And it's really not smart to come out and say, well, these supposed Christians, like,
criticism is allowed in the United States.
Yeah, that's fair. But I think if this does go to a jury trial, think about how that's going to look, right?
If it's
that's going to look bad.
No, and that's one of the things we're going to cover about some statements in this paperwork. Everything has to be authenticated. And just because someone gives a statement, that doesn't mean the statement will be allowed under oath later.
That's true. That's all done during discovery, correct?
Yeah, so remember this the whole point of this letter that you're looking at, guys. This is the ministry arguing that they have a valid claim. That's why you're going to see all throughout this letter, you're going to see paragraphs that start with upon information and belief. That's another way of saying they have evidence to a valid claim against the other party. So they're declaring, and it's actually dictated in the federal rules of procedure. They actually have to write it like that in the paperwork. So that's why you're seeing that over and over. This is years and years of case law adding up to a moment like this. So that's where that terminology comes from. So this letter is just the ministry declaring under penalty of perjury they have a valid claim.
Or they think they do.
They think they do. Yeah, that's what I'm saying. So this will go before a magistrate, and they're going to review the validity of all claims, all alleged evidence. Some a few pieces are highlighted in these papers. So that's what you guys are looking out here. This is not a gotcha. There is no gotcha yet. You understand? Legally, it's not a gotcha until it goes to a jury or a summary judgment where the judge just if it's valid, then the judge will make a judgment later. But there's no gotcha yet. You're going to see that in a little bit. So
where should we start? We'll see. This is jurisdiction stuff. Okay, so allegations. Yeah. They talk about when the International School of Mystery. My God, if I can say it right one time, it would be incredible.
All right, so yeah, go ahead.
Ministry, ISOM, started in 1999. They have basically, it says around 90% of Good Shepherd's activities are carried out under the trademark of ISOM. So that's what they have to defend, right? They have to defend this, correct?
They do have to defend this. Yes, that is a requirement of the Lanham Act. The Lanham Act is basically the key legislation that's at play here in court. So if you're the claimant, so this is what the Lanham Act requires three things. The plaintiff first has to establish that they have a valid, legally protectable mark.
Right.
Then they have to establish that they own the mark. Then they have to establish that the defendant's use of the mark to identify goods or services causes a likelihood of confusion. You need all three. Without any one of those, the whole thing is just shut down. So what they're doing there is just arguing that they have, you're going to see that they're explaining over and over they use the mark. Here's an example of how the mark was used. And this is just them attempting to establish both that they have a mark that's subject to trademark protection, and through more private documents, they would establish through the court that they actually own it. Now, you guys have to understand the importance of that. Let's say there's a clerical error. Let's say there's some kind of mistake made by the federal government. Let's say they got the Shepherd's, let's say they got Good Shepherd's social security number wrong. Well, it wasn't valid. Okay, so that means at the time that he was supposed to register this trademark, that means it's not valid. So if it comes up in court that there was a clerical error, this whole case is just going to be shut down. Now, he's had the error, he's had the trademark since, I believe, 1999, so that's probably not going to happen.
Right.
But I'm just letting you know the importance of having all of your facts straight under oath and by law. This whole thing, especially if you believe this lawsuit is important to yourself, then this, everything you say, everything on paper, every little fact matters. Everything doesn't add up as required, they'll just shut the whole thing down, period.
So do you think when it comes, here's they're just establishing, let's get into, okay, they talk about what they use. They've got audio, video materials, CDs, DVDs, CD-ROMs. What the CD-ROMs?
Right.
Okay.
Yeah,
MP3s.
CD-ROMs, MP3 recordings.
What is a CD-ROM? Isn't that just
in other words, CD? Yeah. Remember, they're actually always called CD-ROMs. It's just CD-ROMs, audio CD. So CD-ROMs basically computer games are CD-ROMs. PS5 games are CD-ROMs.
Okay, that makes sense.
I think that's older format. I think past they were called CDs, even though it's a disc, but in the past they were called CDs. I think because of the size of what we use today, it's actually called something else. But you understand, essentially, you're old enough to know.
Right. And basically, I think what they're trying to do here is show the overlap. In a way.
They are later, yes, but here specifically, they are just establishing that they have been using this trademark, because legally, if you're not actively using a trademark, then you don't have it.
Okay. All right. That makes sense then. So let's get to where they come. Okay. Here's where the infringement begins, or way that they accuse the infringement of beginning. It says on information and belief July and Rippa. Are they treating them as two different entities here?
Well, you also know that we skipped that part, but earlier in the letter it said that with leave of court, in other words, permission of the court, they would later receive the 5 names that have not been given. It just lists 5 John Does. It's possible that Eric July isn't actually his name.
Oh, okay. Okay, so they're treating maybe like Eric July as the name and Rippa as a persona. I don't know.
Right. So they sent this to Rippaverse LLC, right? That's what it's called?
Yes.
Okay. So they sent it to them. Okay, but they don't actually have Eric's full name. So that's why in the beginning of the letter it lists 5 John Does.
Okay.
So their names have still not been revealed. That would have to be revealed. That will have to be revealed later, possibly in the response due no later than December 4th. And also, guys, understand, this is a civil trial. This is taking place in California. California law doesn't actually require a response to any of this stuff. But it is in their interest to respond, because if you want to argue for the case to be dismissed, then you have to state it. Like I said, like when I started this, when we started this a few minutes ago, I explained the value of the oath. Everything you say is taken as a statement of fact. So it's basically presumed true until highlighted that either the statements are invalid or somehow false. But if you don't state under oath that the claims against you are false or invalid, they get treated as if true. So that's the importance of, if you're in deep, that's the importance of cross-examination. Oh,
I think that's a good question. I don't know how they would treat something like that. There is a lot of people thinking that companies like the Blaze have invested in him. I'm sure that would have to come out, but also in a way, somebody could argue that his backers are investors because it's a crowdfunding type thing. So that's a really good question, girl. I'm not actually sure how to answer that.
I don't have an answer for that either. But anyway, like I was saying, everything you say under oath matters, including your response to this letter here. His is due December 4th. Don't expect a response any sooner than December 3rd. And
now, will that be public though?
Yeah, anything you send to a court is public information. Okay. Yeah, so you'll be able to access that too.
Okay, so it says they are a relatively new comic book graphic novel company, marketing and selling the books and related promotional material and other products through USA around the world. Upon information and belief, July and Rippa markets and sells its books and related products directly to customers as well as through retailers. Let's see. It says about the ISAM trademark. They believe he started using that July 9th, 2023, nearly 23 years after Good Shepherd have that, registered that trademark. And in fact, in their own admission, July and Rippa has admitted that in 2022, they launched their entire company, Rippaverse Books, using the ISAM mark. That seems right there like a big deal to me.
It is valid. Again, you can have valid claims that are incomplete in court. So you can have the start, but you may not have the finish. And I will tell you true, as someone who thinks this lawsuit is a bit overdone, there are challenges for Eric. But I'm just here also to explain when the time is right that it's not as clear cut as a lot of people think. It's not as simple as the trademark, because you have to understand there are constitutional principles at play, just like anything in U.S. law. Here specifically, you have free speech outright, and then you have trademark stems from the Commerce Clause. In other words, Congress has the right to regulate commerce or trade in between the states. So that includes products, pathways, and regulations inside those federal territories. Airports are the best example. That's 100% federal territory. That's why states cannot do anything to regulate federal airspace or airports, period. They can't do anything. The space outside of the airports, yeah, they can regulate. The states can, excuse me. But once it goes into federal territory, that belongs to the federal government, and that stems from that constitutional principle. Trademarks are considered an extension of that constitutional principle. So that's what's at play here, and that's also why trademarks. Like, you understand, trademarks aren't like a protected right, not like speech or any kind of privacy, written in state laws. These are things you qualify for, so it's not protected the same way.
Could he not have avoided all of this by just putting Eric July Presents or Rippaverse Presents ISAM #1 on the cover?
By my understanding, that would be a better argument against trademark infringement claims, but at the same time, just the fact that he is using ISOM in his work would be enough to start this. But that's just enough to start. That's just an argument to put this before a judge. It's still not open and shut just from that alone.
Okay. I wanted to highlight this. It's a pre-sale campaign, not a crowdfunder. I don't think there's much of a difference, especially with him having a goal, right? If you have a goal of, I don't even know what his goals are. I think it's 300,000, and the book doesn't get made unless you make that 300,000, then that kind of gives it the crowdfunding feel. Now, we know better. He's going to make that, right? So either way you look at it, what I was trying to argue was that you could say that his backers were also investors in the company, because then again, without people like that, you wouldn't be able to make that goal. That's the only point I was trying to make. Potato.
Right.
Just saying.
Right. So anyway, where should we go next?
All right. We've got them showing examples of ISOM number 1 being launched. Red
Yeah, now
circles.
what you guys are seeing here, let me just explain briefly what they're seeing here. When the point of the ministry's lawyers bringing this up is to establish, again, under oath. I'm not going to say that anymore. Just I want people to understand. If you really want to understand how courts think, you have to understand the oath. So this is them attempting to establish that first off, Eric's work exists. And again, he wants to argue that the use of those 4 little letters, ISOM, are related to the trademark infringement, which again, that's enough for a start. It's not open and shut from there. So we're going to see, as the letter is folded, as Tristan keeps reading, you're going to see, more mention of his products and an argument that these products are possibly confused with each other. Or in other words, the ministry's products could be confused with Eric's products just based on those 4 little letters.
Do you think the arguments that he had, now we'll go through all of this, but he said there was some examples that he gave, right? When it comes to, first off, using your lineage, your ancestry as obviously everyone's going to say that's a bullshit excuse, right? But he gave an example of, like, I believe it was Sonic.
Right. Here's the thing people have to understand. A lot of courts have not weighed a lot of claims. A lot of thousands of claims like this get made all throughout the year. Every year they go to, every level of court, and most of them get thrown out. And even the ones that go, let's say, as high as federal appeals, most of them won't go to the Supreme Court, because this is typically something that the Supreme Court leaves to the lower federal courts, and then the highest court will probably reserve disputes over constitutional principles for themselves. For Eric's argument specifically, the whole thing about surnames, there is legal ground in that. There is a case called Brown Chemical Co. v. Meyer et al. Surnames this was a brief description of the conclusion. Surnames cannot be trademarked, but neither can they be used to deceive the public. So Eric is right to a point. There's actually a test for this called the Rogers test. So we'll just get into it now. And the Rogers test is a court doctrine that they use to distinguish First Amendment priorities from like I said, the Commerce Clause is really where trademark comes from. So it's not just as simple as what's in the federal code. Again, it all comes down to constitutional principles. But the Rogers test is how the courts distinguish or they prioritize First Amendment priorities over everything else. So to answer your question directly, just using the ISOM name as a surname alone, that lends itself to Eric a little bit, but he still has to establish that this is mostly an artistic thing. So if the court finds that it's mainly an artistic thing, especially in California, because this goes to the 9th district. I'll explain what that means later, but basically the district courts here in the 9th district, they have a long history of prioritizing free speech over other trademark issues. So that's also one of the reasons I believe Eric can get this shut down if he argues.
There is also
correctly.
something you're missing here, though, when it comes to the surname issue. He has been quoted on stream saying that it could possibly be an acronym. Meaning, when he came out later and said the reason, and I believe it's reason, there's no reason not to. He never said that until after he was being sued. It was never made known that the reason the character's name was ISAM was after a relative. It was only until after the papers were served, and then previous to that, he had said it could possibly be an acronym.
Well, that's not a conclusive statement, so I don't think there's no gotcha there either way. That's all that's all speculative, even from him. Because you have to understand, just because Eric has said it doesn't necessarily mean it's going to relate to the case that the ministry makes.
But it absolutely relates to the case.
It looks similar, but it's again, you have to have statements authenticated. The ministry can argue, they can bring this before the court and say, this is what Eric said.
Right.
We believe, upon information and belief, they can say that this is related to our case, and it's up to them to say may or may not. Well, like I said, that's not even conclusive. So I honestly don't know how a judge is going to see that. I think you'd have to ask other questions from there. But
Right,
bottom
for
line, I don't
sure.
really know how a
But
judge will see
there
that.
was him saying, like, if as long as it got into court, him saying that it could possibly be an acronym is only going to work, what I'm saying, against him.
Mhm.
Because it doesn't look good, and they're using, well, this is an acronym as compared to a name, right? And a lot of people were saying it meant that at one point he said it meant in search of more because of the main comic industry being basically, some people felt they didn't enjoy what was going on in the main comic industry. They were in search of more, right?
Mhm.
And I think that's clever, don't get me wrong. But what I'm saying is him now coming out only after being sued, saying, well, it's my family. That looks bad.
Well, here's the thing. Whenever you make public statements like that, especially after legal proceedings have begun, yeah, you are taking a risk.
For sure.
But like I said, it all depends on what is related to the case. We have one letter so far from the ministry side, no response from Eric's side. Yeah, as of this recording, we don't have a response from Eric's side. So legally, you need both. You got to compare and contrast and see what stands after the judge says yes or no.
Right.
That's
We can
everything
only
that's read to
take.
her.
Usually,
by the way,
there's
did
one
you
side.
notice? Sorry, I had to bring this up that the judge's name in this trial, his name is Sunshine.
No, it's not. That's incredible.
It's in the final document.
Oh my
Yeah,
God.
not the last page here. It's in the final page of the entire Google Docs.
Oh my God. That's incredible. Like, how lucky are you that your judge's name, Judge Sunshine? Oh my God, I love it.
Yeah, no, it's his first name.
No, it's not.
Just go look again.
I believe.
Maybe I'll take
Oh
a chance.
God.
I'll take a chance. I misread that, but it does say Sunshine. It's
That
the final
is
page
so
of this
good.
document. But let's get back to your argument. Assuming to your statement. Theoretically, yes, but you have to understand what's at play here. The courts are going to look for the rational assumptions of the consumer at the same time. So you put Eric's products on one side, the ministry's products on another, and they're going to look to see what happens when a rational consumer exercises due care. Negligence is not rational behavior. So it doesn't, if somebody just says they just looked at those four little letters, ISOM, that was it. Well, that's nothing. So it's, or like say you find a similar product, similar cola. I think it's a Shasta by example. Shasta Cola has the word cola and it's on a red can. Right? So if you just go grab Shasta Cola because you saw those words cola on the red can, you don't have a claim. That's not really going to be considered a rational exercise of your thoughts.
What they're trying to say though is that it is confusing to the public because of things like the cross, like mentioned here, and that they've actually had examples of confusion.
And again, yeah, I feel like this is where I start to say that the argument's more contrived than not. From ISOM on all all the appropriate products, yeah, you have a valid start. But then stuff like this especially because religious expression is one of the most strictly protected expressions in the courts all up and down the United States. I don't see something like that having any real weight in this case, because you'd be prioritizing one's religious expression over another, and that won't.
I don't think that's going to fly. I think you're missing that there. They're not prioritizing one religious aspect over the other. It's causing confusion, is what they're saying. Causing confusion between a company that puts out leaflets and pamphlets and stuff alongside of their ministry and their DVDs and their da-da-da, to a company that is named similar with Christian-like imagery. They're trying to establish confusion.
Right. Yeah, and I get that. And personally, I'm not sure how that. I don't think that would actually matter in this case. Like, how many products? Let's take the American flag by example. Especially that's like the thing to do now. Put an American flag on
Right.
your stuff. Okay, Shasta Cola, Coca Cola can do the same thing. You just look at for an American flag on a red can, and basically that alone is not enough. If you're a
If you're
rational
drinking
consumer,
Shasta Cola and you think it's Coke, I have questions.
but like I said, it's the word cola on a red can, and that seems to be when people look at trademark disputes, that seems to be the basis of their argument. They look at the similarities, but again, in court, they look at similarities and differences, and they try to establish whether or not the packaging is distinct enough so that confusion, even if it's confusion, can be mild. Things can be mildly confusing. They definitely can't be overwhelmingly confusing. And there is such a thing as a small but significant likelihood of confusion. Like there are cases existing where survey data was introduced, but again, different courts see it differently. Some districts, I forget exactly the case, but they basically determined one district determined that a 10% likelihood of confusion was enough. Another court said a 15%
Oh, wow.
likelihood. Right. So there is such thing as a small but significant likelihood in these cases of confusion. For this specifically, like I said, whether it's an American flag, any religious symbol, these are just such common expressions. I don't think it's going to help. In fact, to answer your question better about those 4 little letters, ISOM, there's also existing precedent. I have it in my notes here somewhere, but there's also existing court precedent that related or similar markings will not actually hold as evidence of infringement if they have been tolerated within an industry for a long time. But stuff like, again,
You really
religious
think
symbols.
okay, the religious symbol. I thought you meant the word
and you
ISOM.
also remember Eric did post a video showing other examples where the exact 4 letters ISOM are being used across or used by other religious institutions, but there are no outstanding lawsuits, at least at the time of that recording.
But they were all different. You realize that, right? When looked into,
some of those were Christian organizations as well. Though one of them was a Muslim, one of them was a Muslim organization, but they were all religious nonprofits, and some of them were even Christian.
Right, but they weren't ISOM. They were, I don't remember right off the top of my head. They were like Indiana School of Ministry or something.
Yeah, Indiana School.
They were, that could be the incorrect name because that was a while ago.
No,
but
that's true.
It was something different.
No, that's true. That when I watched that video a few times to make sure I got that one wrong, because that seemed like his strongest argument.
Yeah, that one I would say was the strongest, but we also don't know, like, if they have, I don't know if you've looked into it or if anyone else has, if they had already went up against them, if they had deals with them, we don't know that sort of situation as compared to this one.
Right, understood. But if they don't exist, if they really don't exist, if there is no court record of such, like previous lawsuits, by example, Eric can argue that those 4 letters have been used repeatedly for so long, and that does diffuse the ministry's argument.
Okay, do you think this is important? Because I have seen not only Robert, but I've seen people talking about this. I think it was specifically Ricada saying that this was actually more important than people realized when it comes to ISOM showing up literally right next to the ministry.
Or, like I said, for Sandman, that's actually not my name, but I am reading your comment. Anyway, like I said, courts are going to look at what a rational consumer would do and the type of care they would take in actually taking in their products. Like our PlayStations, they come with policies, they come with warnings. The video games come with seizure warnings.
I never read that shit.
But the seizure warning is something fixed on every video game. So with a rational consumer with a high likelihood of seizures, ignore the seizure warning. You see what I mean? The stuff like that is
people are stupid.
They might, but see that's not valid to the court. See, here's the thing: you say maybe they're stupid, they're negligent, or they're tired after work. That doesn't really hold in court. I was tired after work. I didn't read my video game first. Well, That doesn't really hold. There are plenty.
No. I
sufficient
just said
warnings
people are
offered.
stupid. That's a fact. I was just joking.
It is a fact, but it's not a fact that really holds in court unless you're actually talking about negligence specifically in somebody's guilt or liability.
Also, bam, I just want to say, boom.
They do have other agreements. Okay. Then that does favor the ministry when they go to court in California. But that
Yes.
still does not mean Eric is stuck. You still have the Rogers test. The Rogers test has to be applied by a court. Okay, so yeah, a few people said that the licensing agreements already exist. All right, so Eric's wrong.
Yep.
He said at the time they're recording, he didn't know of any. That's not the same as saying they don't exist. It also doesn't matter. They exist, and the case has to move forward from here.
Yep. So that is something in their favor, whereas you thought it was an Eric.
No,
oh my
I
God,
said,
Tony, we got to set up a time for the three of us. All it needs is one person. It says
no, that isn't true. Based on existing court precedent, no, it is not. It is not true. But it doesn't require a hell of a burden of proof. That is true.
Right. They're even okay. So this is a fair question to ask because it's definitely part of the situation. There may be some legit people confused, but they're going to have to look at trolls like legit people, right?
No, they are legit. They're people, but they're dumb people. If you can admit they're trolls, you can admit they're kind of dumb, or they're just dicking you around.
Okay, sure. But the point I'm stating here is the court, if you're talking about oath, how important it is, these words are fact. They have to take their words, even if we know, you and I know that it's a troll, they have to take that word as fact.
No, they do not.
Well,
They do
why
have to
not?
in the court? Because everybody's statements in real law, everybody's statements have to be authenticated. In fact, I guess since we got to this point, we might as well move ahead because there's part of it we can stop looking at this guy's crotch. He is circled.
So you've been staring at his crotch
down.
this whole time. I have so many.
You have it
questions.
on screen, you nut job. You left it there forever.
There
Look,
you go.
there
There's
it
even
is
more.
again. And they put better light.
Oh my God. Yes, they did. Okay, here we go. Here is obvious troll. But is that really an argument?
No, like this, and this is one of those things I'm trying to explain to you guys. This alone is not a gotcha. This does not prove confusion legally. Like, first off, if you read this letter, it reads like a snitch. Hi, I'm like, when did you allow this black libertarian named Eric July to use your legally registered trademark? Like, who does that? Do you remember on The Simpsons a long time ago, Homer had to snitch on some friends? He had a recording device in his hat, and he was asking all his friends about crimes. That's how this reads.
No, I don't remember that.
Have you gentlemen partaken in any illegal activities? I mean, and it's funny because they're talking about all this illegal stuff Homer did, and he's saying things like, yeah, illegal activities like that, but involving you. And that's what this reminds me of. This reads like such a... I sense fake intent all over this letter, but if you want to ask, does this hold under oath? Only if the author actually goes forward as an affiant and actually signs an affidavit claiming these statements. Like this, by law, this is called hearsay. And in Eric's response, he can have this dismissed. Now, Eric is not going to subpoena this guy.
They don't need to sign an affidavit. It can be in their proof. All of those.
Nope.
So there was when they put that
Federal Rules of Procedure 801. Federal Rules of Civil Procedure, I believe it's 802, explains what hearsay statements are. This man here, this author, this is called a declarant. This is not an affiant. His statements are not under oath. There's a reason for that. You can't cross-examine what this guy is saying. It doesn't matter that it's just written. Yeah, you can write lots of stuff. Anybody can write stuff. But who has statements related to this case? You don't know that until they're willing to come forward and admit that under oath.
Okay, but it can still be included, is what I'm saying.
If
oh my God, do you remember the Amber Heard trial? We heard voices in different things from people that were included?
Because the recordings were, because people related to the case were in the room of the recording. It's the person. Remember, also
Some of
Johnny
them were dead, Joseph.
But who was there listening?
I don't know. I didn't ask.
Okay, then that's no good. Now you also remember this: Johnny Depp had an issue where he wanted to talk about what his doctor said to him. Remember, objection over and over, sustained over and over.
Hearsay.
Why?
Over and over.
Yes, facts not in evidence. All that over and over. Why? Johnny is there to speak what he has to say. Now, for the doctor's statements, they were in writing. The statements in writing were authenticated. Okay.
Oh my God. I got to Google this because I think you're wrong.
Look again.
I am. Tweets can be included in court. The short answer is yes, whether it's Facebook post, tweet, Instagram pictures, TikTok video, or Snapchat, Snap, social media content can be used in court cases.
Yeah, they can be used, but who's using them? Like, why are they being used? There are a few exceptions to hearsay rules. I don't have them all written down. You have to read the entirety of Federal Civil Rules of Procedure. Or from 801 to 804 explains this, the hearsay to exceptions. If you really want to get that. But this alone by itself doesn't say anything. Lots of people say things. Hey, okay, here, watch this, Tristan. So you're on trial for a crime you know you didn't commit, but you have Facebook posts that say you're guilty. Does it hold in court or not?
Yeah.
So you're guilty just by that? You really think that's
no? Somebody has to prove but it can be. But it can absolutely be used against you.
It can be used, but just because people wrote it doesn't mean it's now legally valid.
No, I never said it was legally valid. I said it can be used as evidence.
That means it can't be used as evidence if it's not legally
valid. It absolutely can. Google it.
What am I Googling? I don't think you want...
Tweets be used as evidence? Can social media be used as evidence?
Yes, but what makes it evidence? You have to authenticate the evidence. Facebook posts like, look, here's an example, guys. Like text messages, Facebook posts, that's basically what this is relating to. Dr. Curry.
Oh my God, Dr. Curry was great.
Okay. There was, a few years ago, there was a woman who taunted her ex-boyfriend until he committed suicide.
Yeah, that fucking bitch.
Hearsay by legal definition is an out-of-court statement presented for the fact of the matter. And the problem with that is it cannot be cross-examined. So that's why Eric can argue that this letter in front of us can be dismissed unless the guy who actually wrote it comes forward. And if he does, I actually do have a few questions for him. Because like I said, the letter reads like somebody snitched on Eric. And don't get me wrong, the man has a way of earning enemies. I don't really have many compliments for the guy. I don't have like the strongest statements against him. He just lends himself to comedy. I'm sorry about that. But if let's say this author actually does come forward, there are some things I would ask him, just some basic questions. Does he know the ministry? Does he know Shepherd? Is he Christian?
He doesn't have to come forward.
He does. Then this is hearsay by federal
law.
No,
it's
by
not.
Federal Rules of Civil Procedure, it's dismissed. Then define hearsay.
I don't have to. I'm showing you right here that social media posts can be used in court in the United States.
Yes, they can, but that doesn't mean you can just write them and put them in court. They have to be authenticated. I'll pull something else up for you, but let's assume this guy came forward because these are questions you do want to know. You don't like, here's another one. Does he know the ministry? If not, how did you know what made you believe that the ISOM trademark belonged to the ministry? And remember, he wrote this letter as if convinced that the ISOM logo was actually lended to Eric for these reasons.
You're just wrong. It's okay. And yes, they absolutely showed tweets during the Amber Heard trial. They absolutely showed tweets during the Vic Mignogna trial.
For what reason, though?
For evidence, Joseph.
I know he has it, but evidence of what? You can't just call it evidence.
In this case, it would be evidence of confusion.
No, but what were the
For
tweets
Amber
in that
Heard,
case?
it was evidence of they did a whole big thing about like what was it? Justice for Johnny Depp. A whole big thing about people voicing their support for Johnny Depp or not liking Amber Heard. Oh, like there was a shit ton.
Mm-hmm. All right. Well, again, I didn't follow every single step of the way, but you can't. Like, I know you can't just because Tony or you write a statement on.
In Amber's
on a
case, it was
trial?
her being harassed. It wasn't just harassment towards Amber. It was also support for Johnny. And
Right.
they can literally show, hey, we're getting this over and over to the point, we're getting this type of email over and over to a point where it's harassment. People are confused. Or we're getting harassment because we've seen it from Eric's fans.
Mm-hmm. Yeah. But is this a harassment suit?
No, but it can show confusion. I'm just saying they can show that stuff.
Well, I'm trying to pull up the. You gotta forgive me. I'm struggling here a bit because I get different.
No, you're
definitions on
fine.
my phone. Wait, I can send you links. What the hell am I doing? I'm gonna have to send the link in YouTube so I can show you guys why you're wrong about this. But
my
what
God.
else would you like to move to?
The email asks questions. It's not hearsay. I don't know. I would say here, I think with so many people weighing in on this, I think this is not going to be hearsay. You're getting people emailing saying it's confusion. You're getting people on their actual social media, even if they're trolls, saying, oh, I didn't know you allowed this new comic book. I didn't know this happened. Even if they're not real, that is what I'm saying. You can
so
absolutely
I just left you a definition of hearsay in the YouTube chat.
Okay, let me bring it up.
Everybody can open that yourself.
It takes me 1 second to bring it up on here. Hearsay. Oh my God, this is the longest definition ever.
Real legal language is a lot longer than you think. That was one of the things that actually, unfortunately, I didn't delete all the texts I kept with my teacher, but there are a lot of them I have to review again because he gives long technical answers as a way of, he would just give long technical answers as a way of just telling me to shut up at the same time while answering my question. He was a funny guy like that. But what you're looking at there, people reading it, they want to understand hearsay versus evidence. So
Okay.
like it says, hearsay is an out-of-court statement offered for the matter of the truth. I reduced that for you people.
Okay. So it's not hearsay.
How do you know?
I mean, I don't know. I'm not a lawyer. I'm just giving my opinion.
I'm not a lawyer either, but look, the problem with hearsay, and it says in the second sentence, the problem with hearsay is that when the person being quoted is not present, it becomes impossible to establish credibility. As a result, hearsay evidence is generally not admissible in court.
They're not trying to establish, they're trying to establish confusion, right?
I know, but it's not credible as evidence of confusion because the statements can't be authenticated. And that's why I'm saying this can be dismissed. Unless that guy comes forward and stands by those words under oath.
I don't know. I think you're wrong. I think you're wrong here. What's this exception?
How do you know this guy named Jerfile actually wrote the letter? Did you see the author? His name is something Roy Jerfile.
Yeah, he's my neighbor. I saw him. See?
Okay, so
it's that easy. No, I'm just kidding. I'm just kidding.
All right, so he's out in your state. You're 3 time zones ahead of me in California, and this man claims he has knowledge of the ISOM trademark. Now, how is he doing that from another state where If he, now let's say he's not Christian, he doesn't know who Isam is. Apparently he does, but then why did he believe that this belonged to the ministry specifically? You still have to, this is the importance of cross-exam. These are things that people have to
Is
look
a
for.
tweet considered hearsay?
By
What
itself,
exactly what exactly are you trying to prove with the tweet you stated? If it's to prove the truth of whatever was stated in the tweet, then there's a good chance it will be considered hearsay. If the tweet is deemed to be hearsay, then the court
right.
Then
and
the
now
court
what is
may
hearsay? Now if it
now
is
we're all
determined to be
back with
hearsay-
this has come full circle.
Right. So all you had to do was read a little bit more. If it is hearsay, then it will be dismissed. And what is hearsay? An out-of-court statement offered to prove the truth of whatever it asserts, which is then offered in evidence to prove the truth of the matter. But if it cannot be authenticated. In other words, the problem with hearsay is that when the person being quoted is not present, it becomes impossible to establish credibility. In other words, they don't know if you wrote it. They don't know if I wrote it. They don't know who the hell wrote it. So they don't know that this is even a statement from somebody that actually belongs in this case. So that's why it
Okay,
gets
wait.
dismissed.
Shush.
Okay.
There are statements made outside the court which are generally introduced to prove the truth of the text or the post. However, courts have largely allowed text in social media posts under various exceptions to the hearsay rule.
And like I said, there are exceptions. I don't know. We'd have to go case by case to actually figure out when it's actually valid.
Right. But
but-
it's saying that they are generally accepted to show a fact other than
Accepted
what you're
or
trying
presented?
to prove.
You say accepted or presented?
Sometimes the court will allow them to show. They are exceptions. I'm sorry, exceptions.
See,
to the hearsay rule.
One word makes a huge difference, guys. Wednesday was not Wednesday Addams was a good goddamn character in a horrible show. Sorry, just yelling at the audience real quick.
Wednesday
I
on Netflix was objectively good. I saw the first episode. I didn't hate it.
If you watch all 8, you'll like Wednesday Addams. You won't like the show. That's what I'm saying. Take Wednesday Addams out of that, and people will go to Wednesday Addams. They will for no reason go back to the rest of the show.
Invincible is mid-common writer. You have terrible taste like me. Welcome.
That's just a mean man.
Right? Invincible is beyond. Invincible is incredible.
It should be called incredible.
Right?
Right. But anyway,
okay, so now that he knows he's
hearsay
wrong.
So generally, hearsay is not admissible for the reasons mentioned. You cannot dissect the statements. You cannot impeach testimony for out-of-court statements. Now, here's the thing. Tweets and Facebook posts, yes, they can. There it goes. They can be presented.
Jesus, Bianca. I mean, Joseph.
No, it's Bianca. She had an out-of-body experience. She stopped by to say hello. But yes, it also depends on why things are being written, who's writing them, and so on. Okay, and bottom line, guys, there are lots of variables at play here. But generally speaking, you can't just write something down, say somebody else wrote it, and then use that as evidence of someone's guilt or liability. It does not work in court that way. So if this guy, Roy Gerfile, I believe I'm getting it based on how it's spelled, Gerfile.
I thought it said
Roy.
obtuse gnome. Where are you getting that name from?
It's in there somewhere.
Oh yeah, Roy Gerfile. Yep, you're right.
Yeah. Okay, so bottom line, if this guy is not willing to come forward and actually stand by the words in this email and say he is the one who wrote that exact email, then Eric's attorneys can ask for this to be dismissed. Eric's attorneys are not going to ask for this guy to come forward. That's 100% on Good Shepherd. But whoever asks,
for sure.
it would be dumb as fuck if hey, you know what? I don't think people know this. I have a $50 charity bet with Tony at the Geek Getaway. My argument is that this can get dismissed. And here's the thing. When I said that, I thought this was going to take place in Texas, where the juries require 10 of 12. I didn't know this was going to take place in California. They only require 7 of 12. And my argument was that the jury was going to be split and that this would get dismissed just on that alone.
Oh, wait. They only require 7 of 12 in California?
Yeah,
And
California only
you
requires
still
70.
don't think Eric's fucked?
No, I said I made the bet before. I said I
Okay,
made the bet
that's fair.
beforehand. But also, we have not gotten to the Rogers test, and that's a big one here. The Rogers test is a court doctrine used to ask the appropriate questions and attempt to separate First Amendment priorities from other priorities written in the Lanham Act. And that matters. And in fact, it's already been done. You may remember this. I think it was Grand Theft Auto 5, but you might remember Rocksteady went to court because they used a symbol from a sex shop in one of the games. And I think it was
What?
Grand Theft
No,
Auto
I don't
5, maybe.
remember that.
Okay,
That's
yeah, it was
crazy.
ESS Entertainment, I think they're called. So they sued Rocksteady because in one of the Grand Theft Auto games, and the whole setting is a parody of the Los Angeles area, and they used a pig pen in a parody in a funny setting to show where that sex shop would have been. And ESS Entertainment, they wanted their money. So when they saw that the pig pen was used, they sued. And the court shut them down because
That's
of
funny.
the Rogers test. Because
Okay,
they
but
said
here,
First
I want to
Amendment
tell you
expression has
something.
priority. Okay.
On June 8th, 2023, in a unanimous decision, the
This
Supreme
year.
Court provided guidance to narrow applicability of the
Yes.
Rogers test in trademark context.
They narrowed it. They didn't strike it down.
Okay.
And you should actually see the facts of this case because
Oh, is this
it
a
was
Jack Daniels one?
Yes.
Yes, it is. Oh, geez.
Yes. And I
That
want
one
you
was
people.
dumb.
Can you highlight that for people? Can we sidestep this just for a second, just so I can make this point, and then we'll
Yep.
get back.
Let me bring this up. I always look on my phone and then I have to email it to myself.
I know.
So I can bring it up.
Yeah, sorry guys. For people who have not been up here on Restream before, I get a video. At least I'll tell you.
It's
what I can see. I get
StreamYard.
a video. But StreamYard. Yeah, fuck. Sorry. Anyway, for either one, we get a copy of the chat from YouTube. We get a private chat from me and Tristan, and we get the video. Okay, at least that's what I get over here. It's actually a little bit clumsier than you think, especially if you're not using a mouse like I am. I have to use the touchpad that comes on the laptop. Anyway, I do know what you're talking about. I did read about this when researching trademark law, but you also have to understand, again, the test is not invalid. And that's what they're saying. They limit it. But here's the thing. They were also talking about the facts of this case specifically. Does it actually show the two products at play? Because I want you guys, especially whether or not you have a bias against Eric, a bias in favor of Eric. Maybe okay. We'll probably just have to. I'll look for a copy of it and then I'll just send it to you in the chat. But I want you guys to see what actually went to court as evidence of possible confusion. Okay. I'm going to send it to you right now. I'm going to send you, this is an image from Reuters that I'm going to send in the YouTube chat. So everybody right now, you're going to be able to click that and see for yourself what was used as evidence of confusion. And I also want people to know that it came up in the courts from the justices. They acknowledge that the two products will never be side by side. Because one is alcohol, one is a chew toy. The reason PetSmart, yours is better actually. The reason PetSmart smells like alcohol is because pet owners are raging alcoholics. They sometimes share with their animal, okay? But there will never be a day where Jack Daniels on the left will be in PetSmart next to a fucking chew toy containing no liquid whatsoever on the right. Now, prior to this case, stuff like this normally would have been decided in the lower federal courts, and it would have already been dismissed under the Rogers test, which again it's the court asking itself, does the artistic display on the right outweigh the trademark on the left? And typically they say yes, especially when you go to the Ninth Circuit where this trial is going to take place. Now, here I just want you guys to take a minute and actually ask yourself. Obviously, you can see glaring similarities.
For sure.
But in what way do you see the likelihood of confusion for two very distinct products?
Well, to be fair, if pet owners are raging alcoholics, they may think, I'm going to get
may.
this.
Okay. Now, I also want you guys to know something
No,
else.
I don't think there's enough there, but.
No, well, there really isn't. Even by the facts of the case you mentioned, the Supreme Court, the reason they sided with Jack Daniels in this, it's actually not because the two products are similar, which is what people think trademark law is all about. It's just about the similarities, and then they think it's open and shut. No, that's not even where this case ended. This case, the problem here was called a trademark dilution. In other words, the existence of the artistic product is diluting the
Did we lose you?
trademark, the legally protected trademark. And
you broke up there for a second.
And I know, and people are laughing. I'm sorry, guys. Can you hear me now? Can you hear me?
Yeah,
Okay,
you're good now.
time,
You sounded like a robot temporarily.
I'm sorry. I said my Wi-Fi goes back and forth. But anyway, guys, what the court really said, in short, that the artistic display on the right dilutes the trademark protections on the left. In other words, the existence of the art on the right dilutes, or it just somehow tarnishes the image of Jack Daniels, a product that is damn near synonymous with raging alcoholics that beat their wives, and somehow it is the chew toy. It is the chew toy that dilutes the product on the left. Okay, so that's really what happened there. It's not as simple as similarities. It's also why they contrasted. But also Jack Daniels argued that the existence of the product on the right tarnishes the image of the item on the left. That's specifically at play, and that matters because unless Good Shepherd is going to make a similar argument, he can't really nullify the Rogers test because the Rogers test still exists. The WWF, honestly,
I don't know much about that case.
No, next time, Tony from the Geek Getaway, he's on nightly, by the way, and he's been covering this stuff too. He said it in better detail. It makes you go, oh, and there's actually more to it than just the similarities of the logos. But yeah, Tony, especially when he goes on his stream, yeah, it's in his interest to cover that again. But he explained it differently. Apparently, there was actually a pre-existing agreement between WWF. Yeah, there was some kind of pre-existing agreement at first because of the possibility of confusion between the two logos. And at one point, the Wildlife Federation, I guess they felt like WWF had gone too far, and that's why it went to court.
Oh, okay.
Right.
So that actually does make a lot of sense.
Right. So again, it's not as simple as the similarities. The courts compare and contrast, whether it's the chew toy and your favorite drink, or even a comic book and a religious organization's newsletter, which to this day, has anybody actually read them, by the way?
Read stuff from the ISOM company?
From the ministry.
No,
we've already said ISOM 1 and 2. And oh boy, and like I said, so you guys understand, I'm not actually Eric's fan. I'm actually on my argument is actually for the law, more specifically the First Amendment.
Right.
Because what people don't understand, and there are lots of issues that go on in court that put constitutional rights. Sometimes the courts will give a lesser priority to our rights in favor of other rights from the federal government. And what we just saw a moment ago with the court protecting Jack Daniels because of a fucking chew toy, unfortunately, that was an example. And that was a unanimous decision. That was Democrats and Republicans. So you don't get to single out the conservative majority and say they're after our rights. The Democrats did it too. So think about that when they say the First Amendment matters. And that's the kind of stuff that I'm really arguing for. It's not about Eric specifically. Again, you, and Tony, we have a future stream coming up. Or when are we announcing that? I know
we can talk about it. I mean, we don't have a time set yet, but we're going to be doing a mock trial where it's going to be. I think it was Joseph's idea, really good idea, fun idea, where Joseph's going to be on the side of Rippaverse, basically, and Tony's going to be on the side of the International School of Mystery, and I'm going to be I guess the court.
You are, yeah, you are the
Yeah,
judge,
and
and so we're simulating a bench trial, no jury, and like initially we wanted a jury, but we thought that got kind of clumsy.
yeah.
So yeah, we scrapped the idea of a jury. We're gonna have some of you guys from the audience, come up here, I wanted to find at least 2 people who sided with Eric. I found one I knew could at least be fair. But again, we just thought that was a little bit too messy. So then we ultimately decided it's just gonna be a bench trial, something that really happens. No jury, just the plaintiff, the defense, and the judge. So that's what we're gonna be simulating. We haven't set a date yet. I think it's might be best if we wait for Eric to respond, just to make sure.
Oh, that's a good idea. Yeah.
Right.
Is
'Cause like I
there an
said,
executioner? No executioner this time.
they don't have executioners in civil trial. That fuck, even in Texas, they don't have that.
So this is a good question though too, or a
Okay.
good statement, so to speak. The big difference between this lawsuit and what's going on here is the importance of online presence. Do
Yeah,
you
it
think
is
that's
all on.
going to take a big I think that's going to be a big forefront of this since they are both all online.
Yeah, it's definitely relevant, but you could also make the same argument. Let's say Costco sells them both. Okay, Walmart, and they both sell similar products all up and down. In fact, Walmart is actually being sued right now by Vans because Walmart brand shoes are similar to Vans. Yeah, Walmart v Vans. Yeah, I don't know when it started, but it started this year. Okay, so it's going to be a while. But yeah, they had now even Vans has a lawsuit against Walmart because they're saying the Walmart brand is too similar to the Vans brand. Maybe it'll hold, maybe it won't. I don't know. But everybody wants money in civil court, guys. You guys also got to understand what's really at play here. This is a civil trial, not a criminal trial. And this is
Right.
also something I think confuses people. In a criminal trial, the evidence is beyond reasonable doubt. This means that the jury looks at the evidence against the accused specifically and votes to determine whether or not that evidence reasonably proves their guilt. If not, then you say not guilty. They don't do that in a civil trial. In a civil trial, the requirement is balance of probabilities. So they're not just looking at the evidence against the accused. They're listening to both stories at the same time and just voting for the one they like better. And so you heard what I said, the one they like better. And this is something I learned from my teacher specifically. In civil trials, they can even be prejudiced. And it doesn't hold on appeal. The only way, anytime you appeal, you're always looking at the judge's decisions. But if you wanted to argue, especially in a setting like this, you wanted to argue for bias from the jury, it's laughable. It's laughable unless the media bias against somebody is so overwhelming, it would seem impossible to find somebody that did not have preconceptions against this guy. Okay, like now, and then this also, he gave me this example. Donald Trump, you're seeing right now, he's already lost one civil trial. He's on trial right now again.
He just
And
lost
people
for the
think-
rape case, right?
Yeah.
Okay,
Yeah,
that's what I thought.
that. But then the one against the state of New York, or from the state of New York, excuse me, that one's still ongoing. Donald Trump will never be able to claim media bias as evidence against him. Why? Because there's media bias for him. There's media bias
Right.
against him. So it's actually the right-wing media and the right-wing media and the people who vote for this guy out of some kind of religiously vote for this man. You are the reason he will never be able to claim a bias of the jury as a defense in an appeal. So think about that when you think the world is out to get him. You're part of it, believe it or not. Anyway.
So, well, the thing is there's no criminal trial to be had here. That's not really. Oh yeah. Hooded said O.J. Simpson lost his civil trial. Yeah.
Yeah,
and
that's
one
another,
is criminal.
Right, right, and that's a great example actually, because he faced 2 trials for the same charges, but under different standards. In the criminal case, he was found not guilty, but he was still liable in civil court. That's also why he moved to Florida, because now he can't collect.
Oh my God, that's so funny.
But let that be an example to you guys. Same evidence, generally probably the same evidence, but different standards at play, and that's how it plays out. So understand what's at play.
They're saying I'm a little bit lower than you.
Okay. No, don't turn up yours. Let me turn mine down.
No.
Okay.
Turn
Shit.
yours up.
Oh, they said you were lower than me.
I know I said it wrong. Shush.
Okay, so I'm too quiet. My mistake. All right. While I figure that out, this is going a little slow for you. So while I figured out, what point would you like to move to next?
All right, let's keep looking here. What do we got? All right, I think this is where they start. Okay, Rippa in July's ISM mark is confusingly similar to Good Shepherd's ISM mark. Also, if this was a name, going back to that idea, would it not only have a capital I?
No, if you can look at anything, Batman, Spider-Man, anything, Superman, they all use capital letters on their,
No, they don't.
on the cover. On the cover?
On the cover, maybe.
Yeah, I don't know. I would say that's just tradition in comics. I'm not sure how a court would weigh that. So like I said, this is weighing something like this is newer to me. I just know that it's not as clear as what is similar. They also contrast. Now this right here, is their best evidence. So my understanding, Eric could be found liable, let's say just like this. And I don't think that means that the mark itself necessarily, I don't know if that means that the mark itself or the ISOM has to be scrapped altogether. But I know at least in this case, he would have to do something. He would
About
have
his
to
merch.
do something more distinct. Yeah, he would have to do something there. That's my understanding. But if I wanted to argue in court, again, comparing and contrasting, not just one, guys, comparing and contrasting. Well, the one thing that stands out to me is the globe in the Ministries logo, which does not exist at all in any way, shape, or form in Eric's logo. Now, here's also another thing. I can't even see the letter O. Actually, let me make this.
Oh, yeah.
All right, good. Oh, yeah, that works for me. Thank you. All right, I can barely see the letter O. Personally, I would mistake that one as ESIM, and I wouldn't know what the fuck that is.
Yeah, I didn't realize how small the O was on that.
Right. So that can be confused for other logos. If I were on Eric's team, I would argue they didn't even take care to distinguish what their logo actually says. I don't know if that's valid, but I would at least try it.
Okay, hold on. I want to go back to something you said just a minute ago. I want to keep talking about this, but I want to go back to something you said about it being specifically a civil trial. You said who they like more.
Mm-hmm.
Now,
the civil jury.
This goes back to a lot of what I've been saying this entire time. If you only have to get 7 out of 12 and you're going at this idea of who they like more, who's presented well, who has shown, once they show a lot of Eric's behavior, depending on what's admissible and what's not, it's going to, that's going to cause a bias, right? If you bring up that video of him saying this supposed Christian organization, don't you think that alone is going to lose some people?
It may not even, this isn't a defamation trial, so I don't think that's going to hold.
You don't think that's going to be able to be shown at all?
No, this is the United States. Part of the freedom of speech is freely criticizing. So it doesn't matter if Eric,
but it doesn't mean it can't be held as evidence when they're directly speaking on them.
Evidence of what? The charges are outlined in one of these pages. There are 4. One of them was from California law, that I remember, and 3, I think, from the federal code. But I don't remember defamation being one of them. So if it's not related to the claims alleged, then it's not going to hold.
Evidence of his behavior. You realize that was outlined in here, right? How his behavior is not in line, basically, with their Christian organization. They will be able to show behavior.
But again, if anything, I say I say that's actually an argument in favor of Eric, because it shows a distinction, not a similarity.
I mean, I guess that's one way to look at it. I wouldn't. Sounds better now. Okay, thank you so much, Dan.
Okay, yeah, so that was my fault, guys. I'm sorry. I turned my microphone all the way up this time. So, but again, let us know if sound bounces in and out. It's usually my fault. Go ahead.
No, I wouldn't look at it that way. Personally, I think it would. it wouldn't have anything to do with the distinction of the product. It would be the behavior involved. If they want to show that they don't want to be associated with this type of behavior, that's a good way to go about it, right? There's a good way to show just how he behaves online. I know they had a problem with him cursing and using the Lord's name in vain. They're going to show all of that.
That they're gonna at least try at the magistrate, the hearing before the magistrate, but I doubt that's gonna hold because that's religious expression. That's a constitutional protection. Can't be used as evidence against you for anything, even in a civil trial.
You're not listening. You're not listening.
I heard
It
what
can
he
be
said.
used to show that it is tainting their brand.
He's gonna
If they
try that.
establish confusion, and then that confusion leads to a brand being tainted.
But like I said, they're trying to throw a lot of things in there together. And some of this is going to be struck down when it goes to the magistrate.
For
so
sure.
What's going to matter, ultimately what's going to matter is what is left. This, like, we're looking for the two hats, the two logos side by side, especially, well, whether or not i.e. loss of potential customers. I understand that, but you can also lose customers because some people like something else better. So that's not really what the courts are looking for. They are looking for the possibility of confusion. And again, it's actually a fairly low standard. Like I said,
but what I'm trying to get across here is if there is confusion established, if they are able to establish that and then show that they are getting, their brand is therefore getting tainted. That's why they need this copyright taken. Right. Why they needed to raise this case. That could taint the 7 out of 12 people. That's gonna, if you get a few religious people in there, you don't know what your demographics.
I understand what you're saying, but you also have to understand that doesn't mean it's legally valid. Because why? We freely criticize in the United States. We freely speak. We freely have different religious, political conclusions. And to that point, Eric, I believe Eric is Christian too, or has said as much, a believer of some sort. But whether or not his belief is in line with the ministry or not is not a constitutional concern because it is his individual right. In other words, in the eyes of the law, whether Eric is a half-assed believer or if he has vows to a church makes no difference. It's all equal. So that's why I'm saying that can be something that, Eric's side actually argues in his response. Just to have that dismissed, just to say, no, this has nothing to do with anything. Remember, it all matters, just like your right of silence. I don't think a lot of people know this, and this is something that came from my teacher directly. Your right of silence from the Fifth Amendment does not matter if you don't actually say it. Like, based on the literal words of the Constitution, it doesn't read that way, but this is what the courts enforce. And this was determined, it was in a popular case, Salinas v. Texas. It was a man, and he was criminal, and he was guilty, by the way. Okay, Salinas was outright rotten. But what happened, he had one trial, and upon appeal, he got a new trial. But in the second time, he didn't talk. He wouldn't talk to any he just wouldn't talk to any prosecution whatsoever. And the prosecution used his silence as evidence against him. Now, based on the literal words of the Constitution, you think that's not allowed, but the court determined that we have to actually assert the right in order for it to be valid. So if you don't assert it, it doesn't get used. Why? Because under oath, it doesn't look like you were using your right to be silent. So that's why I said everything you say under oath matters, whether it's for you or against you. You have to use it. If you don't say it, then it's assumed that it's just taken as somewhat of a gospel truth. It's just taken as a fact of the matter, and yes, it can be used against you. So that's why you have to assert when you have an argument, whether it's a right or just other legally valid, any other legal argument based on what's written in code. You have to say it where it is under oath, where penalty of perjury applies. This letter that you're seeing, penalty of perjury applies. Eric's response, penalty of perjury applies. It all begins with this letter hit and then continues into the hearing.
Let me get this tip real quick. Robert, thank you so much. Both ISOM and the ministry are online exclusive, correct? To my understanding, I would have to do a little bit of research to make sure before I have like a clear answer to that, but I think so.
Right.
Which means searches matter. The ministry relies on these people looking for them. If people associate ISAM, the comic, with Eric and his fans and their actions, it'll lead to confusion of the name searches.
Yes, and like we established at the beginning, maybe you missed it, the rationality of the consumer matters. Does the consumer actually exercise due care? Does anybody here see the white logo and the orange logo? Does anybody here see the logo where the eye is larger than the other? Does anybody here see the logo where the globe is present and the globe is not present?
Absolutely.
Those are the expected behaviors, to my understanding. Those are the expected behaviors of a rational consumer. A negligent consumer is not an argument. Like I said, and this even happened to me, because I drink whole milk. It is awesome.
Ew.
I'll drink. No, you're all screwed up. That's your problem. That's not on me. Like you go Cold Stone.
No.
Oh, see,
Cold Stone. That's like
you never had fun a day
calories.
in your life. Look,
No,
look, I'm watching your subscriber count go down. Look,
No.
I'm gonna count that down to you while I talk about this. But anyway, because we got a bunch of cookies. I was with some friends. We got a bunch of cookies, and I just wanted milk for myself. But I went to the first red and white carton that I saw, which I thought was milk. Which I thought was cow's milk, turned out to be horchata. That's fucking rice milk. It's bullshit. That's not the real thing. That's a crock of shit. I don't care if you like horchata. That's not the point. I wanted the real fucking thing from a cow's goddamn tits, and that's what I wanted to drink with my cookies. Okay, so whatever. But here's the thing: they're red. It's red and white, just like whole milk. It looks the same. I did not exercise due care and actually read what I was getting. All I did was look at the red and white, and I assumed I was getting what I really wanted. So if I were to try and sue any of my logo, and well, to Raymond's point, it says logos usually don't show up in the web search. Okay, that maybe that matters too. But like I said, courts compare and contrast. They're looking at likelihood. You guys got to remember that going forward to keep the conversation coherent. They're looking at likelihood. But anyway, if I were to try to sue local farmers because I grabbed the wrong product, the courts will laugh at me. Okay, I don't have a valid claim there just because I made a mistake. You actually have to look at the just like a lot of sports brands. You've probably seen knockoffs of things like Adidas, by example. In fact,
for sure.
I actually have something in here. It's in my phone. I'd have to send it to you. I have to email it to myself and send it to you. So let's move on to another point, and I'll get back to it. But this right here, like I said, just in case people lost me, I'm sorry we do get sidetracked because we have fun here at the same time. Personally, this is
whole milk. Oh my God! No, I'm just kidding.
That's how you enjoy cookies.
Oh my God! I
guess other stuff isn't milk. It's what's left of milk after somebody butchered it.
Well, maybe.
Okay, you don't.
That's
do
fair.
That. You do not do that to nature's finest. Okay, but anyway,
I can see the point though that they're making, that you're not seeing logos in the SEO, right? You're not seeing anything in your search that says. But I can also see a point. So, to Eric's point here, if you go and you look, International School of Ministry, and then ISAM #1 campaign, but you can tell this is Rippaverse as compared to ISAM.org. You can see they're two different websites. I understand what you're saying, but most of this is for Eric.
Okay, then people like Eric better.
Okay.
That doesn't mean
do they though? Do they though?
I think so. Who knew about the ministry before they filed this lawsuit?
Christians?
I stand correct, woman.
Christians, maybe? No, it's a teaching thing, right? To my understanding. So it does have a rather select audience. I know they do a lot with like Joyce Meyer and some of the other bigger names in like Christian teaching. So I don't
Mhm.
know that my audience would not be the one to ask. Let's be real.
Right.
Anyone that's a Christian has been offended by now and moved on.
Right, but really though, and now here's also another thing. The ministry said they're a Christian organization. They're using that necessarily in their arguments, as if that's that they're presented as if that's a fixture, that's a necessary part of their claim. What Christian distinctions do you see in the ministry's logo that do not exist or do exist, sorry, in Eric's logo?
Nothing.
Right?
Is that what
So
you're
then
saying?
how are you yes, so how are you confusing a Christian organization from a non-Christian organization?
I mean, if you saw Eric July talk, I'm assuming if you were a devout Christian, you probably would be turned away.
Sure, but the question asked right now is not related to Eric's speech. That is non-responsive. Your objection will be sustained.
But that is included. You keep thinking that's not included. It's absolutely included.
But you have to, yes, it will be included. But remember, when trials unfold, they organize to keep everything specific to questions asked. That's why, like Donald Trump right now, he's chewing out his judge, and over and over, and over, the prosecution is saying objection, non-responsive. What does that mean? You're talking about things that weren't asked. That's not allowed. When you're on the stand, you have to respond to the question asked. And remember, in a civil trial, this is another thing a lot of people don't know. In a civil trial, your right of silence does not exist. Whether it's Donald Trump or Eric July, nobody here has a right of silence. The right of silence, that language in the Constitution, nor shall any person be compelled to be a witness against himself. A better way to say that is, nor shall any person be compelled to be a witness against, nor shall any person be compelled under criminal penalty to be a witness against themselves. So that's specific.
One example I can think of you're talking about is when you're not supposed to talk about something else. Do you remember in the Amber Heard Johnny Depp trial, she accidentally mentioned Kate Moss? That opened up the avenue of them being able to bring her in. So that is kind of a big deal.
I believe that falls under excited utterance, which the link I sent you did.
It's really called excited utterance because they were super excited when she mentioned him.
Weren't they? Yeah. Yeah, they
did a fist pump and everything.
Yeah, well, they could have faked it. It's all about, whether or not it holds under. It's all about what holds under oath. The issue with excited utterance being that the person speaking on the stand is somehow, let's say for some reason they're overwhelmed, experience some kind of distress, by example, and just start saying things that may or may not have been relevant before. And therefore the argument being that because of excited utterance or because they're overwhelmed, they weren't actually within their faculties when they said anything. So it's thought that they probably weren't trying to lie under oath. And that's considered an exception to the hearsay rule. But again, just because it's stated, that still doesn't mean it's a fact of a matter. You have to understand in law, there are facts and there are conclusions. Okay, it's a fact. Look, self-defense, perfect example. It's a fact that you shot somebody inside your house. Whether or not it's murder or self-defense is the conclusion. You see what I mean?
If you shot somebody inside your house, call your lawyer right away. Just saying.
I know.
Okay, so about these. Now the argument here is going to be the cross on his dick.
All right. And I
why a cross was placed on his dick? But
no, that's a belly button piercing he puts on after his.
Oh my God!
The man is okay. It's like a half-ass fade to just try to stylize a fro. Okay, this man is a bit disorganized. All right. Here's
also
what I
feel
want
like
to know. How come
isom.org is a bit disorganized? Who designed your logo?
And does Eric use an org?
No, this logo right here. Who designed this? And did you pay for it? Because it's awful.
Well, apparently
Come
it was
on,
Eric.
it's time for a redesign. Oh my God. It's time for a redesign, guys.
Yeah, truthfully, that sucks. But now let's also look at this, because when it was just white, and black, the ministry's logo was honestly confusing to me visually, because I didn't know it actually said ISOM. Now with this, churches have horrible designs.
It was his wife. I'm sorry. It was his wife. Okay. It was.
We respect good
taste.
intentions here.
Yeah.
But we also give constructive criticism, and then maybe she needed something better to drink. But
yeah. Wow.
Anyway, But anyway, so this right here is colored. So this is a bit more clear. So now I can actually see ISOM clearly.
Wow, now you're racist.
What?
Never mind.
What? Because I
joking
said
over your head.
the white logo is colored.
Yeah.
What? No, replacing
So
white is not racist. Have you not been watching the leftist media? Replacing
That's
white is not
true.
racist.
That's true. It's only racist when it's the other way around.
Yeah, that's why people don't understand. Miles Morales, yes, he is Spider-Man. He is Peter Parker in different skin. That's why he is the fucking Spider-Man. Okay, now back to the facts before us. So does anybody here fail to see two very, very different color schemes?
Okay, yes, but
see
okay,
on the
say
left-
you're a parent, right?
Okay.
And you're getting something cool for yourself and something cool for your kid. You may get
I'm
the
not looking to the right.
No, but what
I'm not
I'm
looking
saying is
anywhere.
if you were wanting one for yourself, maybe you'd get one on the left. But if you wanted to get something your kid would wear to school, maybe you would find that ISOM shirt. Probably not. I'm just saying they're
If anything, I would, if I were Marvel, I'd be chewing out Eric because that looks like a bad Spider-Man.
no, it
There are
looks
honestly
like a
better
bad
sp-
Mr. Terrific.
But you know what? There are some really good
Or
Spider-Man
Darius.
knockoffs.
It looks like Darius from Mortal Kombat.
Does he really have that? But does it? But does his suit look more like Spider-Man's officially?
That does not
Has it been?
look like no, that does not
I think you're
look
gonna have
like
to put
Spider-Man.
no, put the superior Spider-Man next to that. We'll do that later. Let's stick to the facts. Okay, so you said hypothetical. Okay,
Hold
let me
on,
entertain
hold
the
on, hold on,
hypothetical.
hold on. It's Darius.
NetherRealm Studio, you have a lawsuit on your hands.
Like
No, he
it's
really doesn't.
he does a little bit. Shut up. Look at it. He does a little bit.
It's a similar color scheme, but I don't think color specifically can be trademarked like that. I don't know. Like I said, I'm newer to understanding trademark law. This much I can tell you is the point I'm trying to hit home to people. It's not as simple as comparisons. It's also contrast. It's not just what is similar. It's also what is different. And we are actually seeing plenty of differences here. So my argument from the start is personally, I don't see this as confusing. When you consider differences at the same time, I don't find this very confusing. And I don't have great eyesight either.
No, I can agree to that. And I think a lot of it came down, and I don't know if it's here, a lot of it came down to their print material. They were saying they both he puts out a comic, they put out like pamphlets, therefore that crosses a line.
Right, and I know Robert has made some arguments about how the writings of the ministry and then Eric's work falls under periodicals.
Mm-hmm.
And again, in light of the Rogers test, it's still not that simple because the courts are going to look at artistic expression. Now, don't let the case with the bad Spaniels and Jack Daniels, don't let that fool you, because the argument was specific to trademark dilution. And did you see? I didn't see any argument for trademark dilution, but they also didn't cite directly, like word for word. They used the actual civil and criminal codes in California and federal law. So I don't know that they were arguing for trademark dilution.
Oh, I don't know. Okay, so it does list their examples here. It says July and Rippa, I'm just going to say Eric. Infringing activities are likely to cause confusion, mistake, and deception among the consuming public as to the origin of the infringing goods. Okay.
Right.
So
and that is their claim. Remember,
that is their main argument.
Conclusions. Yeah. This is just their argument, guys.
Now, confusion, they may be able to prove. They absolutely may. Again, we're going back to that argument of it doesn't matter if it's a troll or not. Do you think Eric's gonna walk in? I seen Robert saying it earlier. Your Honor, it was gay ops. Your Honor, I'm sorry, it was gay ops.
No, that doesn't matter. It doesn't matter if the ministry is gay or not. That's not a crime in the United States or a civil offense. It doesn't matter. So it doesn't hold in court. Just like religious expression, just like it doesn't matter if Eric has a different conclusion on religion. especially in California. The California protection for religion is much more expansive than the literal words of the U.S. Constitution. So it honestly doesn't matter. That's why I'm saying it's not going to hold as an argument in court.
Keep going. That's not what it means. But it was
What?
entertaining. Gay ops means like, what is okay?
No,
hold on.
I know what you're talking about though. When that was just like a saying online when they just
yeah, like if somebody does something,
yeah,
like
they
behind
basically
your
called
back.
it gay because it sucked, not specifically that it was that it was homosexual or I get that, but still, whether it's here's the thing: the courts are going to look at the literal words too. But someone will ask what the hell you actually mean by that. If Eric actually did raise that concern, just like Alex Jones. Alex Jones said some dumb shit under oath.
Oh my god,
it's a straight.
he really did though.
Imagine that objection calls for legal conclusion. This is a straight. No, but
oh
that's
my
true.
god.
But anyway, whether it's gay, whether it's internet speech, whether it is really, the gay is out to get him or anything like that, whether or not I got it right, none of that really matters. Bottom line, there are standards at play, and that doesn't violate them. And if Eric actually tried to get, here's also another thing. I should take this example, guys. So Eric is alleging that this is a frivolous suit. You guys all remember that.
Yep.
You saw the 13-minute video, like 13 minutes and change. Basically, Eric is arguing that this is frivolous. All right, here's a legal lesson for you that also did come from my teacher. In order to establish something is frivolous, you can't do that from the outside. If let's say Eric got this whole case dismissed, that doesn't actually mean it's frivolous. It just means that the arguments presented were not strong enough by themselves to go to trial. That's all it means legally. It does not mean it was frivolous. In order to actually establish something is frivolous, you have to do that under oath in the trial. You actually have to establish some kind of fraudulent intent. Like I've explained this before. The medical, what is that thing? The handicap parking spaces and the license to actually park there. Okay, all you need is a valid doctor's signature to get that. It's at the doctor's discretion to determine whether or not you even need that. If you were to try to say, you give it a shot.
That would never work.
Just tell them you thought She-Hulk was a good show and maybe you'll get one.
They will definitely.
I believe
it's getting a season 2.
For psychiatric disabilities, you can get those too. So
under She-Hulk.
If you tell them She-Hulk was a good show, they might just give you one right then and there. Like, God, you poor woman. You need more help than I thought. Anyway. Okay, so anyway, guys, what matters is the validity of the doctor. Okay. But now let's say it came out under oath, something during cross-exam, because hearsay is not allowed in court. Something during cross-exam, let's say the doctor slips and somehow implies that he knew this patient didn't have anything medically wrong, but issued the license anyway. Now you have an argument for frivolous intent, but again, it has to come out under oath. While the facts of the case are being presented for during the trial, bench trial or jury trial makes no difference, but it has to come out under oath. Okay, now keep that in mind I'll sidestep for just a second. Keep that in mind because how many times have you heard that qualified immunity is only for frivolous cases? I've read the decision in Callahan v. Pearson Pearson v. Callahan, where this was determined. It says nothing about frivolous lawsuits. And even then it doesn't matter because you can't determine something's frivolous if it's not actually in the court under oath. So think about something else for you guys to take home.
Qualified immunity is a stream by itself. Holy shit.
Well, I bet you the way things were going, we'll be back here just for that reason.
Oh my God.
I'm about to email you something. Sorry this took so long. I was trying to find it through the laptop.
So
but go ahead.
No, I know this does play a role into this, and I understand that. Do I think how do I say this?
Well,
doesn't matter at the end of the day.
Only saying that because he truly thinks it's a gay ops and manipulations by Vito and Dick, that it's all false pretense. Yeah, like I said, that letter, whoever wrote that, I think it's the same thing. It does read suspiciously. And yeah, obviously Eric is trying to say this is frivolous, this is a crock, but he cannot safely argue that it's frivolous until it's established under oath. Okay? So he can't do that, but he can still get some things dismissed. Now, whether or not that's an argument to move things forward, I don't know. And this
What
is
the
what I
fuck am I
just sent
looking
you.
at here?
I want you guys, do you guys see something? Because these are logos from two different skincare organizations. Let me get the exact names. The one on the left is New Faces Skincare Centers, skincare specialists. Oh, no. The one on the left is Cosmetic Dermatology and Vein Centers of Downriver. Those are the plaintiffs in a Supreme Court case for trademark infringement. So the one on the left is the plaintiff's mark. The one on the right is the defendant's mark. Now, I want to see from the audience, do you see enough similarities for trademark confusion?
Yeah.
You do. Okay. And I want this to hit you guys in the face. This case was dismissed. The defendant won.
What?
Yes. This is something I sorry, I should have pulled this out sooner.
No, that's a good example though.
Right. And I have to send this to you in YouTube. Oh, no. I think I opened it up here. Let me see. No, but anyway, I'm gonna send you the facts of the case, and I'll just do it in the YouTube chat. Fuck it. That way the audience can get a grip on it, and that way they can read it themselves. Now, this is one of those long reads, but I just want you to show you guys I brought receipts on this. But what you are looking at right here, is keep that up there for a second for people to process. The website I sent, those are the opinions of the court. That's going to take a long time to siphon through. I just wanted to cite that so people can fact check on their own time. But what you are looking at right here is a case that was dismissed. And you can see the no trademark infringement because the courts concluded that the two organizations were
both skincare products
distinct.
Also?
I don't know. That one I don't know.
Wouldn't that be sort of important to know?
It's important.
Because
I do think it's important. Well, here's the thing. I found it this morning. I didn't I didn't have time to siphon the whole thing. Sorry.
The reason I say that is because there would be overlap.
Mm-hmm. Right. Mr. Knox, he says, I can see why it was dismissed. If you can find the valid quote, can you cite that for us while we continue? That way we can continue entertaining the crowd at the same time.
Okay, it says one is cosmetic dermatology. And the other one, provides marketing, bookkeeping, accounting, and general business expertise to the Detroit medical community. So they are both medical.
Right. Okay, so there you have it. You have a similarity, guys. Remember, this is what
Definite
everybody's
overlap.
arguing for. Yeah, so people see overlap, but like I said, in court, they look for, they compare and contrast. They look for what is similar and what is different. And the differences do matter. Unfortunately, to the court of public opinion, Eric is screwed just based on the fact that people see similarities. And that judgment against him is unfair. And that's the point I'm trying to hit home to you guys. You guys got to understand, differences matter. And the real court, and especially, I didn't see where this was actually, what district was this? U.S. Court, Eastern District. Okay, so this was not the Ninth Circuit, but the Ninth Circuit is one of those that would side with.
So how was this then determined if it wasn't the Ninth Circuit?
Oh, this was in, it says up top, this was U.S. Court of Eastern District of Michigan, February 28, 2000. And again, I'm newer to this, so I didn't, sorry, this is one of those things in law. There's a reason people go to law school. They do
for
like
sure. I was just curious if you knew.
Right. No, I don't know. Sorry, I don't have that for the record.
No.
All I
Okay,
can say,
so here's an argument from Raymond. He said he doesn't think it's a good argument. The similarities for ISOM are not under some artistic liberties with a logo, a shirt, or hat. It is the letters ISOM that are trademarked, and there is no difference in the ISOM.
the comic books definitely will be reviewed under the Rogers test. As far as the other merchandise, that is the better argument for the ministry. Can we go back to that?
Yep, definitely.
Okay. But I just want you guys to see a situation where very similar logos, right? Very similar logos were used in a real federal case, and the defendant actually won. And for ISOM's logos, that also depends though, because again, this is also the importance of establishing things to a court. You want to know what is official, what is not, because some people use their own logos creatively all the time, but then what is
Right.
the real logo? What's the real trademark logo? And I believe, based on this letter, I'm assuming they're arguing that the logo presented next to like the two hats, so they're arguing those are the two official logos. Now, this
Okay.
is also another thing. This is also another reason you should wait for Eric to respond. He may actually present a different official logo. I know the one we saw in the hat is basically what we've seen on the comics. It's assumed that's the right one, right? But then
That's
look at
my
how many
assumption.
times,
Yeah.
right? But then look at how many times Spider-Man, Batman, just based on the titles, look how many different ways there are to creatively write the just in the title, on the title page alone. Like the word Batman, by example, that's been written tons of different ways over many different comics. But what is the right way to do it? I would think that's a question that needs to be answered if you're going to say the logos are confusing. So, but again, I don't
Okay,
know.
so looking into this, if you look, it does look like the reason why they're calling them July and Rippa is that's the name of their LLC. And they did file a trademark for Rippaverse,
Mhm. Okay, so
but it was invalidated. That application.
does it say why?
It was
Is there any
refused,
other?
dismissed, or invalidated by the Office of Applications, or is no longer active.
Or is no longer active? Okay, so does it have a date? I can't see based on it gets blurred, but
I'm trying to refresh it.
that could mean that there's another
Wait,
Rippaverse
I'm
out
not.
there.
I am.
Wait,
Okay, so here we go. He's done it 4 times. 4 times. Holy
does it have
moly.
anything to do with the fact that they're an LLC? Because I know LLCs have distinct regulations.
Okay,
I
so
don't know.
he is waiting. The newest one says he is
Oh, okay.
awaiting. Wow, you have to wait that long? That was over a year ago.
That's great.
Wow.
Yeah, I know. Just all kinds of little stuff. But does it have anything to do with the fact that he's an LLC? Does that complicate it?
I honestly have no idea. It may.
Because I know LLCs, they do have their own regulations. Like I mentioned this on a previous stream. I knew a guy that got an LLC during the pandemic because he just wanted the money. He said he was going to start a business. He got a loan from the federal government and he spent it on expensive cars. But in the fine print, it says the government has entry rights and they can go and check on the investment. And then he said, holy shit, they can do that. And now I'm in trouble. So
this is actually a really good example. Okay, Captain Marvel. Captain Marvel cannot be used now on the. Yes, it cannot be used on. Marvel has the name, right? Marvel has the trademark,
right?
And that's why the name went to Shazam.
Shazam. Wait.
Yeah, the character Shazam.
Okay, the character Shazam. So because I forget he exists. I always think of that movie that Shaquille O'Neal did, Kazam.
Oh my god.
Horrible.
No.
I know 2 horrible characters, right? Shazam. Okay, the Shazam
not
movie
that
sucked.
bad.
No, I actually don't think Shazam's a bad character, but I think the movie's bad. The adult version was more juvenile than the kid.
You know what's weird to me about Shazam is it's always like a little like there's always like a hint of it being a little problematic because like when you have this 12-year-old running around with a bunch of adults, it's weird. And then they made it even weirder by having Harley Quinn at one point have a crush on Shazam and get him from school. Like it's no.
Guys,
probably don't do that again.
Art is not the real thing. Please take that into consideration. Read it or don't. Art is not the real thing. But does that change your opinion of Harley Quinn?
No, absolutely not.
Well, you care.
The good of it in a problem. Oh, come on. It's weird when a 12-year-old is getting inducted into the Justice League with a bunch of 30-something-year-old people and like having a crush on Wonder Woman. It's weird. Come on now.
You know what? He doesn't exist. People like that aren't real. I think most people would say no, something's wrong. Bottom line, guys, it's art. Let's get back to the issue at hand. Okay, so he couldn't trademark Rippaverse, but what does this have to do with the ISOM logo?
Nothing. I was just showing you.
No, okay, just that he can't get.
He can't
Okay.
get it. So obviously he knew he could not get it. That's kind of what I was stating here is he knew he could not get it because he has already clearly done some of the legwork with the name Rippaverse.
Did he try to register ISOM?
I'm looking here and it doesn't look like it. There's
Okay.
a lot for ISOM. Holy shit.
Wait, for the facts of that case, I'd actually have to see the court's determine it. Like if anybody knows the court case, because you have to look at the specifics of the court determination. So like I said, everybody here, even right now, still has a tendency to just look at the similarities and say that's the whole of it. And like I said, I just showed you several times throughout this stream. It's not that simple. It's not as simple as similarities. Comparing and contrasting matters. And you just saw a case you thought would have been clear cut just based on the logos. You thought would have been a clear cut win for the guy on the
Right.
left, but it was dismissed in favor of the guy on the right because courts compare and contrast. So that was my argument from the beginning. Eric has enough to contrast with. Now, as far as the jury, like I said, Tony, if you're still listening, the bet still stands. I'm almost at a point where I might as well quit, but I said I made that bet. I made that bet because I thought this was going to take place in Tejas. I did not think it was going to take place over here in California. I might not have actually made the bet, but I still do believe there's enough here to divide a jury. So like I said, it all depends on the arguments made. Hopefully, if Eric does have decent legal representation, hopefully they make the right arguments. Like I said with your Fifth Amendment.
His
whatever your
rock star
defense-
lawyers.
His rock star lawyers. Is that what he said?
Yeah, that's what he said. He's got rock star lawyers. Duh.
That'd be fucking cool. He's got some rock and roll lawyers.
Right? I didn't even know they
He's-
existed.
Anyway,
So weird.
It's like him and his lawyers go to the Rocky Horror Picture Show every year.
Right?
They're
They start.
that kind of rocky. They're that kind of
He-
rock and roll lawyers.
He definitely dresses up as Janet. He definitely does.
I would go as Rocky just because I'm not talking.
Oh my god.
I can't sing though. Court order. Anyway, what we're talking about here. Sorry, like I said, I wouldn't have placed that bet with Tony if I knew this was going to take place in California. I didn't know where the ministry was from. Nobody knew about them until they filed this lawsuit. I can actually drive to their headquarters, to be honest. They're
Wait,
not,
isn't
they're
there
in the same
a-
county I am. But
I thought there was another letter in here.
the file you sent me has a lot of stuff.
Yeah, but I thought there was another letter in here from a father. Or maybe that was in their tweet. I can't remember. But the thing is I understand what you're saying about those two, but I do think there's still some truth to the idea that we're talking about the ISOM word, the ISOM as compared to a logo.
And so do I. No argument from me. No argument from me. There is enough for comparison. And that's, remember, there are facts and there are conclusions in law. A fact that you shot somebody does not mean it is murder or self-defense. Facts have to be unfolded. They have to be reviewed. So, see?
It is the
See, I
first
told
thing. You're telling me this judge had the hippiest of parents. I'm telling you right now. They smoke so much weed, it wouldn't even compare to me. They named
Hey, I
their
bet
child Sunshine.
Sunshine Skies. I didn't see the last name, but I know the judge, not the magistrate. This is the magistrate. For those who don't know, it's basically an attorney given power by a judge for certain things. For in this case, they're going to review what's going to go to trial. The judge is someone else. And the judge is named Sunshine. I bet you this is like a hippie motherfucker that reads comics too and wants to defend the First Amendment.
I love it. That's so cute. That's such a cool name. Robert, thank you so much. Joseph,
Right.
The similarities are just to build up the case. But in the end, both the ministry and Eric's print off periodicals. That's important.
And continue? Just to make sure
Just like how Marvel kept DC from using Captain Marvel on the title, that is what the Ministry is doing. Plain and simple, enough said.
Well, 2 point. First off, I haven't read the facts of the case with DC and Marvel, so I can't argue for or against that. But to his first point, as I've established over and over, no, it's not that simple. I just proved it to you again. I'll send you the link to the court opinions from that case from Justia, so you guys can read that again. You actually read like what kind of things courts are looking for. I just sent it in the chat. You and I can keep talking about this, but that's the stuff you guys got to understand. It's not clear cut. They don't look at what is similar or even just what may be identical, unless it's so identical it's overwhelming. In that case, that would be a dispositive fact, which is a fact or statement that basically makes the whole case. Or similarly, if the trademark, let's say there's an issue at the trademark office, Good Shepherd, for some reason, let's say there's a clerical error, then the trademark is no longer valid. The whole case is dismissed because of the dispositive nature. The trademark doesn't exist. You see what I mean? I don't know what would be dispositive in favor, would be dispositive in favor of Shepherd or Eric, for fact right now. I'm just explaining to you guys how that works. But compare and contrast is what really matters in court. And like I said, I wish I had that one with me, but survey data has been presented.
But the problem you're kind of circumventing here is if you're looking at two periodicals side by side, and both of them both of them have ISOM on the cover, that's where it becomes an issue of relative confusion. Yeah.
Right. And I've said that. And that's also what I'm explaining. And I said that was an argument for the Ministry. That's what this letter is explaining. They're attempting to say that the similarities are enough to get this reviewed in court. Okay, now we have to wait for Eric's response. And I bet you if he does have decent lawyers, they're going to cite the Rogers test in their response and say that this has an overwhelming First Amendment implications. And therefore, they're going to ask for the case to be dismissed on that alone. I doubt the whole of the case would be dismissed on that alone. And I don't know if, like I said, that letter by Gerfile will probably get dismissed if he doesn't come forward. The rest of it, I don't know if that's enough.
But it's not the only letter, right? There's a bunch. There's a bunch like that. There's a bunch of tweets like that. There's a bunch of comments like that. Those all exist now because he made this such a big deal. He, the Streisand effect. This would have been so little. Maybe not. I don't know. A lot of people were covering it. But what I'm saying is he made it so public that it just fueled more comments like that, more social media posts like that.
Okay, and that's fine. But like I said, let's go with that. So you said since his comments, this comments basically is fuel to this fire called the lawsuit from the Ministry, is what you're saying.
Right.
Where was that confusion before his comments?
Well, they showed
Where was that confusion before Eric's comment? No, you showed me a letter that inspired this lawsuit, apparently. And
there was another letter, and that was in a tweet. I thought it was in this document, but I don't have it. It was basically, again, it could have very well been a troll. I don't know. But it was a father writing about somebody refresh my memory. Basically, it was a letter before this had happened, saying that he was confused and no, it was in that time period though.
Okay. Well, okay, so if anybody knows that time period, if you're fast with the Wayback Machine, we're still going to be on here for just a little bit, so if you can anybody with the permissions to send links, please help us out here. Let's see how that looks.
So but what you're saying is the stuff that, okay, so the day Eric put out that video, the stuff afterward, you don't think that they're going to take seriously?
Now, hold on a sec. Let me interrupt you for a moment because Robert is saying that DC has never taken Marvel to court because they know they don't have a case. And again, if public statements and private statements are obviously two different things. If it didn't come out in court, you don't know for fact what was said. If there was a settlement, they can selectively tell you what the settlement terms actually are, or maybe their lawyer said it's just a good idea to form an agreement and avoid litigation altogether. None of that is an admission of guilt. You guys got.
This was a thing that was done when it came to early comics, right? So you notice how everybody has a counterpart. You've got Hawk, you've got She-Hulk. You see what I'm saying? A lot. You've got Spider-Man, you've got Spider-Woman. They would create that character for the ability to copyright it because they didn't want, a Spider-Woman on the Justice League. So that was something that they did quite often.
Wasn't that also the same with She-Hulk? Like they just
yes,
they made
absolutely
the female version. So yeah, okay, yeah, I get that. I understand that. I understand that.
Fucking figure drawing. Weird. I can hear Rob. Yeah. I get it.
Like all of our rooms are getting hotter too. Well, all right. I'm not going to pick on Rob no more. But serious response, guys. You guys have to understand that stuff. Again, everybody's looking at the similarities. I'm doing my damnedest to get you guys to. I'm doing my damnedest to get you guys to understand it's not just the similarities, it's also contrasting. And we were just up here a few minutes ago. We were looking at the two ISOM logos together, and one of the arguments that the ministry makes is that it's presumed that they're pronounced correct, the same. They're pronounced identically.
Right.
I don't know enough about trademark law to know if that holds, but we do see some very plain similarities in the art, in the logos. And I asked a few questions that actually were not satisfied. When we saw the logos in color, okay, we did not see a Christian cross. And somebody's telling me that the Christian cross matters, but there's no cross on either logo. So if the official logo is the source of, I forget the court terminology. Source of, not confusion, the source of the trademark, I think is what they say. So if that's the official logo, so that's supposed to be the source for the consumer to focus on and guide them to that product. And you're going to say your Christian nature is key to selling your product, then why isn't that a feature of your official logo?
Okay,
I would confuse that argument, but just from that.
We've got I love it doing this homework. The subject logo, okay, so he read through the New Faces skincare case. The subject logo does not serve and has not served as any identifying functions for New Faces, and it cannot, as it has never been used with any particular goods or services. So that is why the case was dismissed.
And that's also something I know I learned recently. They look at whether or not there is an endorsement from one or the other. So if you're the defendant, they look at that there's an endorsement, and I think that had its own definitions. I'm trying not to screw it up too much, but basically that's something they look for in attempting to determine if there's any possibility of confusion, like if there's any endorsement for the main whoever had the trademark first. They look for stuff like that, and I think that's what they're referring to here in that determination. So in other words, they're not seeing any kind of attempt to mislead, or they're not seeing any kind of I'm trying to remember the actual definition. I'm sorry, guys. I'm gonna back
No,
off
you're
that.
fine. We actually have a question for you. Hypothetically, let's say the church had a great lawyer and Eric had a standard one. How might that change the outcome?
That could be very bad for Eric because, like I said, the arguments you state under oath are the ones that are going to hold. Simplest example, your right to silence. If you don't use it, then it does not stand. The court's not going to do it for you. The prosecution sure as shit isn't going to do it for you. More than that, courts have already determined the prosecution doesn't do that for you. They determine that if you're the accused, you have to be the one to state, I invoke the fifth. I choose to remain silent. I choose not to answer questions, or I will not answer question without lawyers present, or something like that. But you have to be the one to say it. If you do not say it, where penalty of perjury applies, then that means the court will assume that you're just not going to use it. So that's an assumption that any statements made against you, like by the prosecution, or if let's say if they actually use your silence against you, then it's assumed that you're just going to allow it.
Now I actually have a question.
Okay.
Do you think now you know these people are paying attention, right? The International School of Ministry is absolutely paying attention to the online sphere. They commented on Raketa's video. They've used Tony's videos on their personal, is it called Vimeo or something? Their own personal platform. So they're absolutely paying attention to the chatter surrounding this. Do you think that they could use so Eric did those false copyright strikes. Do you think that they could use that and say, look, he understands copyright because he's used it before?
That no, because copyright and trademark are two different things. In fact, they stem from two different
Fair
constitutional
point.
principles.
I didn't even think about that.
Yeah, the right to copyright is specifically mentioned in constitutional law, and trademarks are an extension of the Commerce Clause. So these are enforced very differently. So I don't think copyright specifically matters.
And again, not a lawyer. Get those confused sometimes. I forgot all about that. Yeah.
Sorry, like things happen. Yeah.
Well, I mean, it was ironic to me, right? That he's done this and used copyright, and then this happens. There's just a hint of irony there. Come on, we've got to at least admit that.
I know people are tempted to draw parallels, but you have to understand that in law, parallels don't necessarily matter. It's all about the context of the code and constitutional principles at play. You should try and read something like the federal rules of criminal procedure, federal rules of civil procedure. This is going to take you days to read, and this is just years and years of case law unfolding and establishing consistency over what is presented under oath and what is not allowed under oath. It's a lot of reading. You're going to feel like you're back in nursing school all over again. Okay, I haven't read through all of it.
No, I'm just kidding.
Okay. What,
no, reading. I was joking.
Oh, you're reading this. Eric's lawyer has to know he can't keep him under wraps. And
reading in I was saying ooh to reading. Never mind, it went over your head.
Oh, reading in general. Oh, okay.
Yeah.
All right. No, he's not talking, is he? It's always figure. No, it's always figure drawing that has a smart ass at me. But
hold on. He has a really good point here, because if this goes to a trial, I mean, it seems likely headed that way. We don't know, if it's a jury trial. Getting him on that stand compared to getting someone from the actual Good Shepherd is going to be night and day in attitude, in the way that things come across. Eric has a very pretentious ego.
Right, but like I said, guys, and I know people don't like, and then look, you can meet people who know him and they're going to say the opposite of you. In fact, Tony from the Geek Getaway, he had one of Eric's, I don't know about immediate neighbors or former neighbors, but somebody who's met the guy, somebody who knew him. And he gave a number of thoughts.
Isn't that this guy?
Is that you, Chris?
I'm pretty sure it is, because I watched that video.
Okay.
I'm pretty sure it is. And he's the numbers guy. Because I always find it funny. He does such a good job with the numbers, and then Rippaverse still comes in there like fake numbers. Yes, those are real numbers, you dumbass. He's lost nearly 50% of his audience each time. Come on now. By the way, I apologize ahead of time if you end up on Rippaverse goalpost or whatever.
Oh, that fucking
They don't usually use me, which is good, but you may be that guy on there that they're like, ho, he thinks he knows what he's talking about. But we have 4 brain cells to rub together.
Anyway, but yeah, like I said, to figure drawing's question, yes, the quality of your lawyer matters. The quality of your defense matters, because, like I said, everything you say under oath matters. It's basically treated as a statement of fact, assuming it's legally relevant. And then that's the importance of impeaching testimony, to make sure you actually have all the legal relevance. Okay. So yeah, your defense matters. The ministry could win this just because they have great. Yeah, I know that guy is such a shithead. Though. Like, why are you?
I know.
Like, why are you acting?
I've never seen anybody.
Like Eric has. Well, but why is he acting like Eric has money to spare for him? Like, you're
right?
Not his
I've
woman,
never
ho.
seen anybody simp
No,
that
you want
hard
your
for
money.
any
You go back to your
creator.
corner. You work for your own. Alright,
Freaking
but no,
craziness.
alright,
And he's got a whole channel. I am not kidding you.
I haven't looked
That
at it.
does not do faces or like not faces, but voices. His whole channel is like
It's
this
just
AI
quoting us.
voice. Yes.
Oh,
No, I mean a YouTube channel of all like the quote unquote detractors, but it's not even his voice. He doesn't even commentate it. He uses AI to explain the situation.
mhm.
It is wild to me that people are even mildly interested in something. You have to be a whole new level of obsessed.
Comics descended into a cult. You know that. Elon Mudd, he's been here. He basically said that. He said, um, even though I'm paraphrasing a little bit, but he relates to the goals of the Comicsgate movement, but he won't actually say he is part of that movement and
Right.
part of the reason, at least that's based on something he said to me, I know of, that he said they're more cult-like than anything. He actually doesn't want his name on that. He wants people to enjoy comics because they enjoy them, and you could
Elon's
see
awesome.
why. Yeah, no, Elon's great, but you could see why if you take a side in a if you take a side in a debate where you arguably have cults at play, then you can understand why that would limit your audience responses. Elon wants to bring back days where anybody, no matter what you held true, at least you could look at his work, and see that he has something to say, even if you don't agree with it. And honestly, his work is great. I had a chance to review a lot of it, and holy shit, I wish I could tell you more of it, but fucking guys
His
got to keep some shit
ideas
under.
are fucking hilarious too. When I had him on, so good. Like, and he's so passionate about that. That's what I like to see in creators. That passion really shine through. Whereas I want to know, about your creators' your creations, motivations. It's
Right.
what it wants to do, the world it lives in, all these things. You got passion from somebody like Elon, right? Where on the
Right.
other side, when you're looking at someone like Eric, you've got my fucking detractors, my fucking people that hate me. Like that. Okay. It's not entertaining to me. It's not fun. Comics are supposed to be fun.
And everybody's got a bitch fit when they just don't get their way. Like what? And you join a cult knowing these people? You see
Right?
you see what I mean? That's your cult leader. But like I said, guys, I don't have any strong personal biases against Eric. At least I don't think so. I don't frame him that way in my mind. But the thing is, he
Right.
lends himself to comedy. And like you'll see, for those who missed it, we did announce earlier. We don't have a date yet, but Tristan, myself, and Tony from the Geek Getaway, we will be back here in a later date coming soon, and we are going to host a mock trial
It's gonna
for
be
Eric.
awesome.
Yes, for the ministry, for the ministry and Eric July, and we are going to present the facts so far. Because you gotta understand, this hasn't gone to trial yet, but we're gonna wait for Eric's response. We're gonna see what he says, and then I will be defending Eric. Tony will be defending the ministry. The judge, even though I don't think you should be on the bench at all, Tristan, who has a clear bias
When the
against
idea
Eric.
came up, I'm like, I am not smart enough to do this. I will officiate.
Right, all you're doing is moderating our arguments, and that's perfectly
Yes.
fine.
Uh,
Okay,
So last question before we wrap up.
okay.
Did talking about this out loud, throwing ideas back and forth with the chat, did any of that change what you think the outcome of this will be?
Fundamentally, no, and here's why. You guys got to understand, like I explained earlier, again, for those who missed it, civil trial, it's a very subjective standard. It's people back off lawsuits, they go to settlements. Typically, that's framed as an admission of guilt. That's not the truth. The truth is, sometimes it's better to settle than face the unpredictable nature of a civil trial, of a civil jury. Okay, especially, like I said, California, 7 to 12, and it's a subjective standard. You're really
But
likely.
you almost wanted to take your bet away. So there's a little bit of doubt in you.
No, but that's because I thought it was in Texas. Because I
Yeah.
said I didn't.
Yeah.
Because I doubted. Here's the thing: I doubted the jury would be unanimous. But the point being that I expected the jury to be divided. Now, divided jury in California likely means that liability falls on Eric, and that is unfortunate. But I'm standing by the bet. I'm not looking for a way out of the bet. Bottom line, guys, I have a $50 bet with Tony, charity bet. Winner picks their charity, and I stand by it. I've announced it multiple times on streams. You guys know I pay super chats. I give tips. Okay, well actually I don't give you tips. I don't know why. I don't know, for some reason I can't sign into PayPal. But anyway, I'm not going to back off the bet. I'm not going to back off the bet. Okay, so to answer your question more directly, no, I still have the same conclusion that Eric has a fighting chance, and that is Eric like Peg.
I love Mo.
He's debatably screwed. Like I said, it's a lower standard in California, 7-12 in a civil jury. It doesn't seem like those odds are impossible to beat. You know, civil trials have a very low standard. The ministry honestly could use a half-ass argument. I was asked earlier, what about ministry's great lawyer and Eric's modest lawyer? Let's try it the other way around. Let's say the ministry has a half-ass lawyer, but Eric has a good one. 7-12, that's really not a hard standard to beat, but it all depends on what's presented at trial. My argument only being that he has a fighting chance. And this is also something that frustrates me because First Amendment issues are at play. And we're in the chat, we're in a conversation. I'm in the conversation right now with a longtime comics enthusiast. We have a bunch of those all over this chat room. So here's the thing. What's at play right now? Your First Amendment expression, and that includes art. Why? Because speech doesn't have to be coherent. So you can be as creative as you want. You can say something or don't. It's your choice. It belongs to you. But then you also have trademarks dispute, which stem from other rights of Congress. And what happens, as you saw earlier with the Jack Daniels case, and a chew toy that looks like their alcohol. And you saw the Supreme Court unanimously sided with Jack Daniels because they thought the chew toy, especially with a dog shit logo on it, it was on there somewhere. I don't think we zoomed in on it, but it was on there somewhere. They thought that was trademark dilution. So in other words, that the existence of this chew toy destroyed the image of Jack Daniels, as if being associated with abusive fathers isn't enough.
All right, guys, we are going to wrap up, but make sure you guys come back tomorrow. Today's Bianca's birthday, but we're celebrating it tomorrow on Bad Ideas, and I'm super excited trying to think of some fun things to do.
I'll be there too. Happy birthday, Bianca. Eric July, if you're listening, it doesn't matter if I don't like you very much. Fight this all the way to the top because you have a chance.
Out of control. You were out of control.
A small chance is still a chance.
All right, we will see you guys next time. Bye-bye.
Have a good one, guys.
I can look at